Whatever the matter you want to mention, give to my court officer, but the reason should be given why you are mentioning. If there is no reason, it will be not listed. Uh, hmm.
18 buffaloes were intercepted by the police, and they are in the custody of the police. Now, you not the agency is there.
So I told you, what are the urgency? Give to my court officer. Write the urgency. I will see in the chamber.
May I permitted to
I
mention?
will not waste the time in mentioning. Yes, call the matter.
May I permit to mention one matter, one order sheet, my lord, of 13th, my name has been wrongly recorded, my lord.
Give the number
Yes,
mentioning.
yes, yes.
Or should make it short.
Paso.
Lordship, I have short password.
Paso.
Your Lordship, in this case, I am appearing on behalf of the DRI.
Lordship,
But-
in this matter, the petitioner's advocate, Mr. Somraj Pal, is conducting advocate in this matter, and his flight was today, but due to delay of flight, he could not appear before the court within time. Lordship, kindly not today, kindly fix this matter tomorrow, Lordship.
In that case, kindly fix it Monday. Monday.
90.
Right, my lord.
Forum for the petition.
Yes.
Lordship, short passover and the State Council Niloy Chakraborty perhaps on the other court or not yet reached.
Who is for the petitioner?
I'm for the,
Yes, what is the case about?
my lord, case on the NDPS Act.
Hmm.
My lord, my grounds are twofold. Firstly is the gross violation of 52A of the NDPS Act, number one. And my lord, secondly, the grounds of arrest have not been provided to me. My lord, I'll take your lordship to the written complaint at page 12.
Page 12.
Page 12. Page 12 of my application.
Yes.
Lord, we'll see the bold 560 grams of brown sugar.
Yes.
Now, my lord, the violation of 52A is from, my lord, takes up page 20.
Page 20.
Page 20. Page 20 is, my lord, the certificate of inventory. Lord, will find the date at the top, 24th day of July 2024.
Correct.
And my lord, thereafter takes up page 21. Page 21, which is the CFSL report. Lord, will find the first paragraph. It says, please find enclosed herewith the forensic examination report number such and such, dated 25th of October 2024, in connection with Khodiwari PS number 219, dated 16/7/2024, received wide memo number 189 of 2024, dated 19/7/2024. So, my lord, the certificate of correctness was obtained on 24th of July. Before that, on 19th, these samples were allegedly, not allegedly,
24th of July.
24th of July, my lord, page 20.
Uh-huh.
That is the certificate of correctness.
That's the inventory.
Yes, certificate of correctness. Before obtaining the certificate of correctness, the samples were already sent to the CFS as is a rule. Hence, my lord, gross violation of 52A. I am governed by Simranjit Singh's judge. Simranjit Singh versus State of Punjab. I'm governed by the judge. Now, my lord, the second ground is, my lord, the grounds of arrest. Now, my lord, in the year 2025, your lordship very well knows that we have been intervened with a flurry of Supreme Court judgments on this front, which says that the law is oblivious. The law presumes that a person is oblivious to his arrest till the time the grounds of arrest are not provided to him as per the constitutional mandate. Now, my lord, in an NDPS case, it cannot be said that since contraband was recovered from my possession. Hence, I am already aware that what are the grounds of my arrest. That is, my lord, strictly that view will be, my lord, regarded as strictly against the dictum of the Supreme Court, as has been held in Ashish Kakkar, my lord Bihan, Provin Purmudars.
Where is the arrest memo?
This is the arrest. This is the memo of arrest, my lord. Nothing as regards grounds of arrest.
Who is the witness in the arrest memo?
My lord, the witness is one Bibhas Chetri. He was picked up from the way by the.
Not your relative?
No, not relative.
Not relative?
Not relative. But firstly, allow me to place, my lord, Simranjit Singh on the ground of 52. Lord, para 16 at page 2. Para 16 says, subsection 3 of 52A requires that the magistrate shall, as soon as may be, allow the application. This implies that no sooner the seizure is effected and the contraband forwarded to the officer in charge of the police station or the officer empowered, the officer concerned is in law duty bound to approach the magistrate for the purposes mentioned above, including grant of permission to draw representative samples in his presence, which samples will then be enlisted and the correctness of the list of samples so drawn certified by the magistrate. In other words, the process of drawing of samples has to be in the presence and under the supervision of the magistrate, and the entire exercise has to be certified by him to be correct. Unless this is done, sending the samples to the CFSL and obtaining the report is, my lord, violative of this particular provision. The next, my lord, I'm relying upon a judgment passed by your lordship, my lord Anant Grover versus State of West Bengal, in which your lordship was pleased to quash an NDPS proceeding.
একটা copy দেন।
Excellent.
Yes.
The operative part, my lord, is at page 7. After discussing in detail,
Yes.
your lordship was pleased to make these observations at page 7. It says, considered the above circumstances, this court finds that the procedure adopted by the investigating agency is total in violation of the provisions of section 43 and section 52A of the said act. Then your lordship refers to certain judgments and ultimately goes on to quash this entire NDPS proceeding.
In this case, the first seizure was made by the authorized person. Subsequently, purely Bob Douglas sitting in the police station made second seizure of the those of said alleged narcotic was already taken possession by the complainant at the airport. After the seizure is made, Bob Douglas inventory was made and placed before the renal magistrate for certification. As per the order,
Copy দিলে ভালো হয় না? একটা copy দিচ্ছে না।
the narcotic is already received by the state drug control, which is unimaginable. Considering the
না, এই যে আনন্দ গ্রোভার বললো যেটা, এটা তো রিপোর্টেড জাজমেন্ট।
yes.
Yes. My lord, on the point of grounds of arrest, Vihan Kumar is, my lord, elucidative enough to convince your lordship to my limited knowledge.
Which
Lord-
paragraph you are relying upon?
Para 21 at page 13.
Page 13.
Yes, sir. At page
Yes.
13.
Yes.
It is, my lord, enumerative. Para 21A. I'll read out all the requirements.
Correct.
It says the requirement of informing a person arrested of grounds is a mandatory requirement under Article 22(1).
Correct.
The information of the grounds of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person effectively in the language in which he understands. The mode and method of communication must be such that the object of constitutional safeguard is achieved. When arrested accused alleges non-compliance with the requirements of Article 22(1), which is in this case, the burden will always be on the investigating officer agency to prove compliance with the requirements of Article 22(1). Non-compliance with Article 22(1) will be a violation of the fundamental rights of the accused, guaranteed by the said article. Moreover, it will amount to a violation of the right of the personal liberty guaranteed by Article 21 of the Constitution. Therefore, non-compliance with the requirements of Article 22(1) vitiates the arrest. I am not concerned with the proceeding.
Correct.
I am concerned with the arrest. Vitiates the arrest of the accused. Hence, further orders passed by a criminal court of remand are also vitiated. Needless to add that it will not vitiate the investigation, charge sheet, and trial. But at the same time, filing of the charge sheet will not validate a breach of constitutional mandate under Article 22(1). E says, when an arrested person is produced before a judicial magistrate for remand, it is the duty of the magistrate to ascertain whether compliance with Article 22(1) and other mandatory safeguards has been made. F says, when a violation of Article 22(1) is established, which is the case in the present one, it is the duty of the court to forthwith order the release of the accused. That will be a ground to grant bail, even if statutory restrictions on the grant of bail exist, which is an NDPS. The statutory restrictions do not affect the power of the court to grant bail when the violation of Articles 22 and 21 and 22 of the Constitution is established. This judgment was, my lord, subsequently followed in Ashish Kakkar, as your lordship very well knows. And my lord, I'm placing a coordinate bench judgment. This awesome last exam. Sorry, Lord, I'm referring to the office copy because this is the only one. Lord Pankaj, all the way from Pankaj Bansal to my lord Ashish Kakkar was considered in this order, and my lord, bail was granted in an NDPS. So, my lord, that is the crux of my submissions. I am praying for bail.
Lordship,
Yes.
Lordship, just now my junior friend brought the case diary. The case was allotted to Mr. Niloy Chakraborty. So far, I had a glimpse on the case diary. It's a joint possession of 560 gram of brown sugar. That means there is no ambiguity. That is, it's a commercial quantity. First of all. Secondly, my learned friend nicely argued regarding section 52A. My lordship, the case diary clearly reflects that the inventory was done not on 24/7/2024. It was done on 19/7/2024. 19/7. I'm placing the case diary. 19/7/2024, and subsequently it was said. But is right. I'm reading the relevant portion. As per order number 1 dated 18/7/2024, IO Amar Bardhan SI of Police Khoribari PS came to my chamber on 19/7/2024 around 1 PM with 6 number of packets. The said packets were found to be duly sealed and labeled, and the said packets were opened in my presence. 19/7. So the question of 52A.
What is the answer to the page 20?
Page
20 of the bail application and C. This is your report, no?
Yes.
This is the page 89, which you're showing from the record CD. This is your record. This is the station house office, investigating office.
Yes.
Correct?
The inventory was conducted on 19/7.
Show me the inventory. Where is the inventory?
That I have placed before your worship.
This is your, who has prepared this?
Just
Whose signature is there?
judicial magistrate.
The last signature of the judicial magistrate. Where is the original CD?
We have received a certified copy.
Why you persons are not bringing the original CD at any time?
Lordship, what happened in the previous coordinate bench said the certified CD will suffice because if the original CD.
Certified copy, but how the court can ascertain this? So what about the page 20?
এটা কোথায় দেখো?
It was signed on 24th, but held on 19th.
It was held on 19th and signed on 24th. The inventory was held on 19th. After holding the inventory, it was sent and it was signed on 24th.
Where is your CD? Dated, which dated 19 July? 16 July?
19 July.
19 July. Where is your CD dated 19 July? Show me.
পেজটা বার করো। This is Lordship, page 89, certificate of correctness of.
That is the correctness CD. The investigating officer maintain the CD.
Yes,
What he has done, what time he has done,
Yes.
what time he has left the PS, what
Yes,
time he
yes,
has.
sir. Yes,
went to the-
he has to make an entry in the case diary. Yeah. You go to first 16th April. 16th April, 16th April, the application was made. Peter Barco. বেশি দূর চলে যাচ্ছে।
Your investigating officers are not maintaining the.
Yes.
Where is that? There is a format of your CD.
In page 30,
Page,
in page 30,
give.
first of all, I submitted a prayer for certification of correctness of inventory.
Give.
In page 30. Actually, just now I have got the case diary, so I have not got the ample opportunity to go through it. At top, just top.
What is the date?
16/7.
16
16/7.
July.
16 July.
Yes,
Yes, sir. No, takes up
first
52.
part has gone. Next.
No, my lord, it is not one. 52A4.
No, I am satisfied.
My lord, if unless the samples are certified by the magistrate, they will
It is
not-
satisfied, it is in the CD.
No, my lord. The certificate of the correctness, certificate of the correctness was dated 24th of July 2024. Page 20 remains, my lord. Whatever may be there in the CD, page 20 remains, which is the certificate of correctness of
Okay.
inventory. My lord,
Record and order.
A4, my lord.
Record and.
For once, my lord. Unless it is certified by the magistrate, this cannot constitute primary evidence in
Okay.
90 PS case.
Okay, you challenge.
52A4 says that.
Okay, you challenge it.
At present,
I have no mood to challenge.
at present, Bela Trivedi's judgment, this is the matter of
In the
trial.
bail application, all the things is to be not, this court has found that it has been complied with. With regard to the 52(4), you take the trial.
That is what Simranjit Singh says.
No,
That judgment.
Bela Trivedi contradicts.
the court is having the all
But
records.
finally, Justice Dipankar Datta has, if I may, substantial compliance has to be there. In the year 2025, my lord, there is a Lord kindly takes up para 15 of this judgment.
এর কপিটা দেবেন, আমরা কিছুই জানি না আমরা।
Para 15 says, we have also found from the materials on record that there has been clear non-compliance with the provisions contained in section 52A of the NDPS Act, either possibly due to lack of experience of the investigating officer or his lack of knowledge of the relevant provisions of the NDPS Act. There was lapses which were duly noted by the sessions judge. Thus, we are unable to hold that there was primary and reliable evidence, which is 52A4 below. Unless the certificate is obtained, the samples cannot be sent. Because with the certificate, the samples constitute primary evidence.
Where is the report sending the CFS, sending the materials to the CFS?
19th of July.
Take this.
That was 19, but
Let me see.
CFSL received on
Sending to the CFSL. And what are the documents sent to the CFSL? Where is the forwarding letter?
just
Where is the forwarding letter sending to the CFSL and what are the documents sent to the CFSL?
Yes, this is a Central Forensic Lab, 22nd July, 22nd July, one sealed paper packet. Page 82.
and certificate obtained on 24.
This is a central forensic. Where is your IO's forwarding letter? What is the procedure? Can I teach you? What is the procedure for sending to the CFSL?
Lordship knows far better than me. I must send it with the forwarding
That's why
letter.
I'm specific. I'm putting the question to you. Where is the forwarding letter sent by your SP to the CFSL along with the Caesar, along with the Alamat?
Alamat, along with the Alamat, yes. Sir,
But page 21 is evident. It is 19th of July.
Twenty-one is again you are telling. 21 is CFSL.
No, 21
What is the
says,
forwarding
Lord
letter?
received
That's
by
why I want to see
that memo number.
what you are taking the 52. When they have forwarded.
Yes.
this is exhibit challan. Lordship, perhaps these two pages may satisfy page 76 and page 77. Yes, I got the CD, no? I'm trying. Instead of the physical. Top case original হবে না, মানবে না। যা বলে দাঁড়া দাঁড়া দাঁড়া, তুই বল ওখানে গিয়ে যেটা ঘটনা সেটা সিনোপসিসটা বল, আমি এটা বলছি।
Where is the certification of the magistrate?
Page 89,
Page 89.
held on 19th,
Held on 19.
held on
He has
19th.
forwarded the report to the special judge NDPS on 24th.
24th.
Correct. So where is the certificate? This is the, where is the certification? This is the report sent to the district special judge NDPS. Where is the certificate?
Certificate is
This is the report.
no, certificate is page 89.
Kindly come to the page prior to page 88 of your CD.
Lordship is taking huge pain to do.
No, he has raised the point of law.
Yes, they obviously yes, there is
The
the
point of law has to be
Oh, has to be
certain.
Lordship, if I am, maybe I am wrong, but so far, this is certification of correctness.
That's why that certificate, kindly see the sign. Signature,
Judicial magistrate,
judicial date.
24th.
Then if he has conducted 19 July,
Huh.
the certificate is issued on 24 July.
Hmm.
How you have sent the materials on 19 July to the CFSL?
Lordship, obviously, one thing I
And
should
kindly see the page 78.
page 78. Lordship,
There is no mentioning with regard to the certification.
page 78.
78. Memo, memo of sending the materials to the CFSL.
Page 77.
77, 78, I may be.
77 is a letter for delay in sending the exhibit. And 77 is the 76 is the forwarding.
Forwarding. memo.
Forwarding.
Forwarding. memo.
And 78,
78.
history of the case, nature of the forensic examination required.
Correct.
Yes.
Kindly see this in that it is mentioned, including this certification. It was sent to the CFSL. Now it can't be because it was sent on 19.
It can be, but one thing, Lordship, maybe this lacuna is there on part of the investigating officer. But one thing, Lordship, section 52A, 52A, subsection 2, subclause C, that is the question is whether it has been tampered or not. The first important point is
No. That is with regard to a trial time.
that
At the time of grant of bail, once the accused has raised the point with regard to you have not followed the procedure under section 52, so the court has to see if it is not followed, he is entitled for bail. The court has also clarified it will not go with regard to the quashing, that is the different matter.
That is
He has not paid for the quashing. Here is the he has
only one line. The pertinent factor is to draw representative samples of such drugs or substances in the presence of such magistrate.
Correct.
That has been done.
Correct.
And this is a very technical fault.
Not technical point. Not technical point.
Not
Not technical point. Kindly come to the page 21
Page 21 of the petition.
of the
petition.
application. Of the application. And you are read with 77, page 78 of your CD. So it has been sent to the CFSL before the certification. So how you can send the certificate? The material is pending before the magistrate for certification, and you send the material 19/7 to the CFSL.
Lordship, this is my humble submission that Lordship knows prosecution far better than me. But this is my humble submission that this is entirely the matter of trial after the Bela Trivedi's judgment.
Okay. Recorded. And no, just, and kindly come to the arrest memo.
Memo of arrest, no, there is no ground of arrest. Lordship, in this case, Lordship, it is, so far,
Kindly come to the arrest memo. Come to the
so
arrest
far,
memo.
so far I have read Lordship's mind. Lordship's opinion is when you are signing the scissor list, when you are signing the scissor
No,
list.
that's correct. That's your opinion. But now kindly come to this, because that case, I find that is mentioned in the, kindly come to this Caesar memo, which I have passed an order. He was the person who signed the Caesar memo, but kindly come to this Caesar memo. 2C,
Two,
2C,
yes,
notification data, time, arrest, nil.
nil. But column 10 has been filled.
Then kindly come. Signature of the witness, either member, family or respectable person. Who is he? Where is the description? Clause 10.
Obviously.
Clause 10.
Yes, clause 10.
Then counter signature of the attestee certified by the person has been informed to the right the person informed. Where is that? To whom informed? Clause
Actually,
11.
desktop work,
Clause 11.
clause 11.
Please do not admit to that, then it is a desk work.
Record and all. Give your CD. So and so appearing for the petitioner. So and so. You are for the state.
State.
So and so for the state. The petitioner has filed the present application. Again, your arresting officer tempered the document. Kindly see this arrest memo and kindly see this. If I will be here, your investigating officers have a tough time.
Please tell, bring the original case diary from the next. This is the reason original case diary.
क्या बोला? Appearing for the petitioner, so appearing for the state, full stop. The petitioner has filed the present application
Lastly, with the permission, may I go to court number 4?
under section 483 of Bharatiya Nagrik Suraksha Sanhita 2023. Praying for bail. Counsel for the petitioner submitted. The police of Kharibari, PHARA, Kharibari Police Station registered a case being FIR number 219 of 2024, dated 16th July 2024, under section 21 within bracket small c / 22 within bracket small c and 29 of the NDPS Act 1985, corresponding to CR within bracket NDPS case number 54 of 2024, pending before the learned special judge within bracket NDPS, comma, the learned additional sessions judge, comma, second court Siliguri. Pending with that, counsel for the petition submit that the police has falsely implicated the petitioner on the allegation that 560 grams of what is the
No, brown
brown sugar?
Brown.
Brown sugar has been seized from the possession of the petitioner. Position of the petitioner. Position. Counsel for the petitioner submitted that on the very same day the petitioner was arrested, and since then the petitioner is in custody and correctional home. Police. Investigation completed.
Yes, that should submit.
He submitted that the police has completed the investigation and submitted charge sheet. But no charge is framed.
No.
Charge is framed. But till date, no charge has been framed. Counsel for the petitioner submitted that the petitioner has filed, counsel for the petitioner submitted, the investigating officer has violated the provisions of section 52, capital A of the NDPS Act. The petitioner has drawn the attention of this court to the letter issued by the Judicial Magistrate First Court, Siliguri, dated 24th of July 2024, wherein he has forwarded the report to the Learned Special Judge NDPS Court, Siliguri, intimating that the Learned Magistrate issued certificate of correctness of inventory in the instant case. Counsel for the petitioner has also drawn, the petitioner has also drawn the notice to this court to the forwarding letter dated, what is the date? Page 21, dated 30th October 2024, issued by the Director, Central Forensic Science Laboratory, Kolkata, to the Additional Chief Judicial Magistrate, Siliguri, forwarding the forensic examination report and returning the remnant of the exhibit, wherein it is mentioned that the Central Forensic Science Laboratory, Kolkata, has received the materials and the request in connection with Khari Bari PS case number 219 of 2024, dated 16 July 2024, for examination of the materials on 19th of July 2024. Counsel for the petitioner submitted that as per the London Magistrate has issued the certificate on certificate of correctness of the inventory on 24th of July 2024, but the police authorities have sent the materials to the Central Forensics Laboratory on 19th July 2024 before obtaining the certificate of correctness of the inventory. And as such, the investigating officer has violated the provisions of section 52 capital A of the NDPS Act. The counsel for the petitioner, in support of his submission, has relied upon the judgment in the case of Simranjit Singh versus State of Punjab, reported in 2023 live law within bracket SC 570, wherein the Honorable Supreme Court has held that subsection 3 of section 52 capital A requires the magistrate shall, as soon as may be allowed the application, comma, this implies that no sooner the seizure is effected and the contraband forwarded to the officer in charge of the police station or the officer empowered, comma, the officer concerned is in law duty bound to approach the magistrate for the purpose mentioned above, including grant of permission to draw representative sample in his presence, which samples will then be enlisted and the correctness of the list of samples so drawn certified by the magistrate. He further relied upon the unreported judgment passed by this court in CRR number 162 of 2024, dated 16th May 2024, wherein this court has held that the police authorities have sent the alamats to the to the forensic laboratory before the certification is obtained. And this court has certification is obtained fully. I mean, special Learned counsel for the people recommended in the present case also. Though the learned though the materials was placed before the learned magistrate for certification, but prior to getting the certification, some of the materials has reached to the CFSL Kolkata, which is total violation of the provisions of section 52 capital A of the NDPS. Learned counsel for the petitioner further submit that the investigating officer, the police authorities have violated the provisions of Article 22, 21, and 22 of the Constitution of India. He submits that the petitioner was arrested on 15th of July.
Yes,
On 15th of July 2023, an arrest memo was prepared. But in the arrest memo, there is nothing is mentioned with regard to the ground of arrest. And in the arrest memo, though one signature has been obtained, but it is not mentioned whose signature is there with, and what is the relationship with the petitioner. Full stop. The counsel for the petitioner also submit that in the arrest memo, there is no countersigned obtained. Countersign has been obtained to prove that the arrest of the petitioner has been informed to the relatives. The counsel for the petitioner, in support of his submission, the petitioner has relied upon the judgment in the case of Shiorpalli Srinivas, SUREPLX, Shiorpalli Srinivas versus State of Andhra Pradesh. State of Andhra Pradesh reported in 2025 INSC 414, wherein the Honorable Supreme Court has held that non-compliance with the provisions. Now, this is for 52A.
yes. That is Vihan. Vihan versus State of Haryana.
Supreme Court in the case of Vihan Kumar versus the state of Haryana and others reported in 2025 INSC 162 and submits that when the arrest person is produced before the judicial magistrate for remand, it is the duty of the magistrate to ascertain whether compliance of Article 22(1) and other mandatory safeguard has been made or not. Full. Counsel for the petitioner submit that the police authorities have violated the provisions of section 52 capital A as well as Article 21 and 22 of the Constitution of India, and as such, the petitioner is entitled to get the bail. Per contra, learned counsel for the state submits that the document, that is the certificate which the petitioner has relied upon, is a forwarding letter by the learned judicial magistrate to the learned special judge, informing that the learned magistrate has issued certificate of correctness of the inventory as per the order passed by the learned special judge in DPS court. And NDPS court. Full stop. He submits that. He submits that this certificate is not. He submits that the investigating officer has produced the materials before the London magistrate for correction for certificate of correctness, and subsequent and thereafter only the materials have been sent to the CFSL for obtaining expert reports. And thus the investigating agency has not violated the provisions of section 52 capital A of the NDPS Act. As regard the arrest memo, the counsel for the state submit that clause 10 of the arrest memo categorically reveals that the relatives or the respected member of the family have been, of the locality have been informed with regard to the arrest of the petitioner. And the petitioner has signed the seizure memo in which the alleged narcotics have been seized, and the petitioner had the knowledge why he has been arrested, and as such, there is no necessity to and as such, it cannot be said that the petitioner has not been informed with regard to his arrest. Heard the learned counsel for the respective, counsel for the state further submit that admittedly the narcotics seized from the possession of the petitioner, and it is the commercial quantity, and the petitioner has not made out any case to come out from section 37 of the NDPS Act, and thus the application filed by the petitioner is liable to be rejected. Heard the learned counsel for the respective parties peruse the materials on record. The police, on information, has apprehended the accused and seized the alleged 560 grams of
Brown sugar.
brown sugar. Police, after the seizure, the petitioner was arrested. As per the record, the investigating officer has made an application before the special court NDPS for correctness of the certification of the inventory. And the London special judge NDPS has directed the London Judicial Magistrate First Court Siliguri for issuance of certificate of correctness of the inventory. Police. As per the record, the materials were placed before the London Magistrate on 19th of July 2024. But there is no record either in the CD or there is no record in the CD to say that on the very same day the London Magistrate has issued the certificate of correctness of the inventory. On contrary, in the CD, it reveals that the police authorities have sent the materials to the CFSL Kolkata with the request. On contrary, in the CD, it reveals that the police authorities have sent the materials to the CFSL Kolkata with the request to provide report with regard to the materials seized by the police from the alleged possession of the accused on 19 July 2024 itself. The forwarding memo from which the materials have been forwarded to the CFSL Kolkata does not reveals that this said forwarding memo contains the certificate of correctness of the inventory. From the record, it reveals that the certificate which the petitioner and which the prosecution has relied upon is been issued by the London Magistrate only on 24th of July 2024, and the same was forwarded to the London Special Judge for information. Police. As regard the arrest, also this court find that arrest memo was prepared on 15th. Arrest memo was prepared
15 July.
Where is your arrest memo?
15 July.
On 15th July 2024, and at serial number 10, one person's signature has been obtained, but it has not been mentioned what is the relationship of the said person with the accused, or whether he is the respectable person of the said locality. Full stop. In this said seizure memo, also not made any justification with regard to arrest of the petitioner. Justification with has not specified with regard to the arrest of the petitioner. Considering the above, this court find that the police authorities have sent the seized alamas, that is the narcotics, to the CFSR Kolkata before obtaining a report from the magistrate, before obtaining the correctness, a certificate of correctness of the inventory from the magistrate. Accordingly, this court find that the authority, the police or the investigating officer has not followed the provisions of section 52A of the NDPS Act. Thus, this court was of the view that this court find that the petitioner has made out a case to overcome with the provisions of section 37 of the NDPS Act. 37 of the NDPS Act. In where the petitioner may get, accordingly, this court inclined to grant bail to the petitioner, subject to furnishing bond of rupees 10,000 with 2 sureties. 1 surety must be local. Full stop. At the time after full stop. If on bail, the petitioner shall appear before the trial court on each and every date of hearing, and he shall not leave the jurisdictional police station without the leave of the trial. CRM census disposed of.
Question one indulgence,
Census with this satisfaction of the special judge and the PS Siliguri.
52 এর সার্টিফিকেট ছাড়া পাঠিয়েছে। ছেড়ে দাও।
Five IFL.
তোরা করে দিবি তো?
Yes.
No time for the petition.
Lordship, I'm praying for a short passable, Lordship.
Why?
Lordship, senior counsel is in court number 1, Lordship.
Let me hear then see.
Not a similar circumstance and also a peculiar one, my lord. Takes up page 16, the relevant portion of the chart sheet.
Page
16.
16.
16.
Yes.
Now, my lord will read from the 4th line on 18/10/2023. On 18/10/2023,
Yes. He
he forwarded the
FIR.
FIR named accused person before learned special judge under NDPS Act with 7 days PC, but the learned special judge did not allow it and sent a prayer for inventory certification, photographs and samples seized before the learned court. On 19/10/2023, prayer for jail gate interrogation. Accordingly, learned court passed an order to allow the prayer, order number 2 dated 19/10/2023.
Why jail gate? He was not arrested.
No, my lord.
No.
He was arrested and after that.
He was sent to
yes,
correctional
he was
law.
sent to judicial custody.
Then thereafter further
Yes,
in
jail
yes.
gate.
Then
Previous IO interrogated the accused Sanju Barman, received OS from learned JM First Court, Shiliguri via order number dated 1/12/2023 regarding allowing to draw representative samples in the presence of judicial magistrate first class First Court, Shiliguri. Now hereafter, my lord, it is important. Accordingly, the previous IO did the inventory, collected samples and marked it as S1, sealed and level done before the learned magistrate, duly signed by the magistrate, and took the photographs of the inventory by the photographer. On 14/12, my lord kindly marks this date. On 14/12/2023, sent exhibit to the director of SDC and RL, 2nd Convent Lane, Kolkata, 15, duly forwarded by learned ACJM of Shiliguri Court via CMR number 343 of 2023, dated 15/12/2023, and received the same copy from SDC and RL while lab number 4421 dated 22/2/2024. Now, my lord, very peculiarly, these samples were sent admittedly from this part of the chart sheet on 14th of December 2023. Now, my lord, in that context, kindly turns to page
14, what?
14th of
December sent exhibit, yes.
yes, on 14th of December sent.
Correct.
My lord, kindly turns to page 17 thereafter. In that context. 14th of December sent.
Hmm.
And my lord, this is the CFSL report, page 17. My lord, will find the date of receipt. Laboratory and on the right side, my lord, at the top on the right side, date of receipt.
Laboratory number census date of
And my lord,
receipt
date of
22
receipt.
22nd February.
22nd February. My lord, almost 3 months it takes for a sample to reach the FSL from the police station at Jalpaiguri. That is, my lord, my first point. There is every possibility of tampering with the samples. Thereafter, my lord takes up, again comes to the relevant part of the chart sheet. I have read till, my lord, 22 February 2024. On 6/1/2024, the IO collect the certification of correctness of inventory.
Correct.
Photographs and samples and seized contraband as per the previous IO, new place handed overs, etc., etc., etc. So, my lord, 14th he sent the samples. 6th of January he receives the certificate of inventory. And, my lord, the samples end up in the FSL after a period of 3 months. And hence, my lord, was violation of.
No, first 14th sent exhibit S1 to director CFS.
Yes,
Second convention so and so so and so. Correct.
Yes.
On 6th January, the IO collect
certificate
the
of,
certificate of correctness. So 14/12, there is no certification.
no certificate.
Yes, then,
So,
so 6th January has sent. 6th January, IO collected certification of inventory, perhaps photographs, census as per previous IO posted a new place. And then census and so. And
so
those
there are, my lord, 3 important things.
took over the investigation 21/3.
Yes. 14th of December, samples sent.
Correct,
6th of January, certificate received.
correct,
And samples end up in the FSL on 22nd February,
February.
after 3 months.
February.
Gross violation of 52A and, my lord, rule 14 and 15 of the NDPS.
So what was sent on 14th December?
Actually, not know, my lord.
Yes, then
Hence, my lord, 52A, that is my ground, and, my lord, the grounds of arrest.
what
also-
is the seizure? What seized?
My lord, only 36 bottles of cough sachet.
Yes.
And, my lord, the period of custody is also important, 574 days.
Delay of sending the
No, there are 3 contradictions. Have you page 16 of the bail petition? Page 16, investigation note. Page 16. First, I was telling that on 14/12, exhibit S1 to the director of CFSL. Then second said that 6th January 2024, collect the certification. And third date is the CFSL received on 22nd of February. So which material you have collected the report?
But actually, the conduct by the Urju and the is unfortunately duties personally not in a position.
Who?
Urju Choudhury.
Can it be tomorrow?
Come with this 3, these are the 3 things. Page 16, 14 December 2023, the first investigating officer has done all the things. Took photograph, magistrate, signed by the magistrate has also done. And 14 December 2023 has sent the materials to the CFSL. Correct. Then again, what materials have been placed before the magistrate on 6th January? And what about if he has sent on 14th December, how the materials are reached on February 2024 to the CFSL? And this is 22nd February.
I'll check and come back.
Collected the certification, so and so. So and so applying for the petitioner, so and so applying for the estate or additional PP. What you are designating estate?
Ballot.
For the estate. Police stop. The petitioner has filed the present application for grant of bail. Police stop. Counsel for the petitioner had drawn the attention of this court to the investigation note of the investigating officer dated 8 April 2024, wherein it reveals that on 14 December 2023, exhibit were sent to the director CFSL. Subsequently, it is further mentioned in the report that on 6th of January 2024, IU have collected the certification of the correctness. And third, he has pointed out the date wherein it reveals that the laboratory of CFSL, State Drugs Control and Research Laboratory, has received State Drugs Control and Research Laboratory has received the materials on 22nd of February 2020. The state is directed to justify and clarify the above contradictions which is mentioned in the investigation report by 19th. Let the matter appear on 19th.
Great.
Actually, I will contact on 19. I have 20.
Yes.
My lord. The petitioner boarded the aircraft from Mumbai.
Huh?
The petitioner boarded the aircraft from Mumbai
Hmm.
and he landed at Calcutta at 2:25 p.m.
Hmm.
And he was detained up to 8 p.m. on the pretext that his luggage is missing.
Hmm.
Then apparently at 11:45,
Hmm.
he was arrested on the ground that on his luggage some contraband has been found.
Hmm.
So there was no conscious position
Hmm.
when he boarded.
Whose luggage was that?
My lord,
Luggage belongs to whom?
luggage belongs to the petitioner,
Hmm.
but it was no conscious position, my lord. The conscious there has to be.
Luggage belong to you.
My lord.
Correct. You boarded from the Bombay airport,
After scrutiny and check, and he was
checking
allowed to-
whatever it is. There is a tag in the and there will be a tag in the your briefcase or suitcase or luggage, whatever it may be.
My lord.
There is a tag of the airport,
My lord.
and that tag have been identified here. That is your bag.
My lord.
So,
But that was in that throughout this period, it was not under his
so
control.
nobody is in the luggage room of the aircraft, sir.
That is the suspicion. My lord,
Earlier 3 times
My lord.
was built.
my lord, there has to be conscious position. It was not in his physical position, not on his.
What is the difference between the conscious person and
My lord,
physical position? Yes.
If my lord kindly comes to para 21.
Hold on a minute,
Yes.
Conscious position refers to a scenario where an individual not only physically causes an drug or psychotropic substance where it is not, but it is also aware of its presence and nature. In other words, it requires both physical control and mental awareness. In concept, this concept has evolved primarily through judicial interpretation, since the term conscious position is only explicitly defined in the NDPS Act. Is not explicitly defined in the NDPS Act. This court, through various of its decisions, has repeatedly underscored that possession under NDPS Act should not only be physical but also conscious. The conscious possession implies that the person knew that he had the illicit drug or psychotropic substance in his control and had the intent of knowledge of the illicit. It's so, my lord.
So
So it
that's
was
why.
not,
So since beginning, what I am telling to
my
you.
lord, it was not in his physical position, my lord. The bag was.
Okay.
My lord,
Next
that-
point.
that
Next
is-
point.
That is the number one, my lord. The number two is, my lord. The rule, the NDPS rule, seizure, search and sampling that has been 22, section rule that has been violated.
What violation?
My lord. My
What is the violation, sir?
Running page number 14.
14. 1-4.
One.
Yes.
The rule, clause 14 says the sample after receiving by the CFSL, it has to be, report has to be sent within 15 days. If it is not possible, a report should be sent to the IO. IO will collect that and definitely within 1 month it has to be sent, but it is.
What?
The samples after examination.
After examination by the CFSL,
CFSL.
it has to send to the IO.
It has to be, report has to be sent after receiving by the CFSL within 14 days,
Correct.
15 days,
Correct.
and it can be extended up to 1 month.
Correct.
Now here, it was received on 1st of April 2024.
When it was sent?
It was sent on 31st.
Where is that?
It is in the.
31st of?
31st of March.
31st of March.
And it was received on 1st of April.
31st of March, which year?
2024.
And
on the next date, that is 1st of April, it was received.
where is the sending report?
My lord, my running page number 19.
19. Yes. Yes, which paragraph, sir?
10.
10.
In the bold letters. Prayer for certification of inventory, drawing of samples and the photography of procedures and certified inventory by the JFSM and the code are annexed as also on set of photographs including DVD containing said photographs have already been submitted before the additional session judge, special judge NDPS Act to CGM on 31st/3/2024, and it was received on 1st. Whereas the report was sent on 14th May. We have to,
This is, where is the report sent to the CFSL? This is a report sent to the, sent by the magistrate to the special court. Where is the report sent by the police to the CFSL?
it was received. The point comes after receiving. That it was received on 1st April.
Who received?
The CFSL. It has been stated in that report itself.
Packing details on 1st April 2021 received one sealed green paper in Achar. You are telling that once, so and when the inventory was conducted, 31st, correctness inventory seized drug on 21st. Certified the correctness and inventory of the seized drug. 31st the certificate and
In para number 30, it is written.
yes. In the course of chemical.
Collection of chemical examination, 31st/5/2000 chemical examination, and before that, test memo dated 28/3/24, forwarding letter to CFSL Calcutta authority, authorizing Ashim Mandal to carry the samples and receipt of the copy, deposition CFSL, and it was received on the first. Subsequently, it was in the paragraph number 10 also it is stated. Subsequently, learned magistrate.
Just a
certified-
minute. This court is not so fast, sir. What you want to say from the paragraph 13?
Not paragraph 13, madam.
You have just read the paragraph 13?
Paragraph 10.
Yes. Yes, paragraph 10, I understand. Paragraph 10, it was on 31st of March.
Yeah, it
The
was.
certification was done. This is a contention. And with regard to the paragraph, page 14, they have sent the report is administered, they have sent the report on
They have received it on 1st
first of April.
April.
Correct.
Send of report on 14th May. The signature, the left.
They sent the report on 14th May.
Okay.
Correct.
It has to be sent within 15 days.
That is the only contention.
That is a violation of rule.
Where the certification was done?
Certification was done on 28th
Where?
at the magistrate office.
At the magistrate. Where is the magistrate? Which court?
Siliguri, my lord,
Siliguri. Where this was sent? Report was sent?
to the CFSL, Kolkata.
Kolkata. Yes. When you are sent the materials.
My lord, there has been no new ground. All the ground was actually done. Lastly, the bill.
I am telling one question. Court is asking one question to you. Show me the document when you have sent to the CFSL.
Unless CD is required. Tomorrow it will be fixed.
When I had about 20 minutes, what you have done? Broad smiling since beginning.
Tomorrow it will be fixed.
You have not have a CD. Why you have not mentioned earlier? Why you wasted the time? Not today. Yes. Who is for the petitioner? Who is for the state? Nobody? Yes. How many grams? Or how many kg?
It is cup serum.
How much?
My lord, I am praying for a short Passover.
For what?
Case diary is not with me, my lord.
Why?
A short pass.
Sir?
My lord, I beg of your pardon. Short pass.
Passover.
Lordship, I'm for the state. 8 and 2, my lord, same similar case, same accused joint position, 1 CD, 2 case has been filed.
Okay.
I'm for the petitioner.
You are for the petitioner. Yes.
My lord, present petitioner is languishing in custody since 380 days.
What is the stage of the trial?
My lord, till today, copy is not supplied. And after submission of charge sheet, as charge sheet. was
When the charge sheet
submitted,
was filed?
In the 28th of October 2024, charge sheet was filed. And after submission of the charge sheet, 14 respective dates were passed, but till today, supply of copy is not done by the learned trial court below.
You are in, so you are appeared before the court. You have been brought before the court on each and every day.
Yes, ma'am. Yes, ma'am. And,
So why the copy is not served?
my lord, they are saying copy is not prepared or anything. No date was fixed for supply of copy, my lord. And next date is 16th of May. That is tomorrow.
What is the quantity?
10,000 bottles of cough syrup, 10,000,
10,000 cup
You-
syrup. Both.
both joint position.
Jointly.
Joint-
Joint
jointly.
position. So why you are not supplying this?
Lordships, may I, Lordships? So far my case is concerned, your Lordships, the date has been fixed on 21st April 25 for production and charge hearing.
How
and
the
next-
charge?
Framing
The
of
char-
charge.
How the charge if the supply 207 has not been
Lordship,
complied with?
both are taken the same day for production, framing of charge, same. And so far the.
Who is the judge?
Lordship,
On the same day, production of the supply of copy and the charge can be done.
No, my lord. And next date has been fixed on 16/5. Prior to that, one date has been fixed.
The court is asking only one question whether copy is supplied or not.
No, my lord.
So why?
Maybe, Lordship, as because we don't have any.
So let I am bringing them out and your investigating officer go in.
Lordships,
That will be better.
No, my lord.
You are playing with the person's liberty.
No, my lord. And earlier occasion as because there is no cause, the details of
When
the
the charge sheet was filed?
charge sheet has been filed on.
October 20.
All things are putting burden upon the High Court and you are not doing anything in before the trial court.
Trial. My lord knows better than us, my lord. You know the.
What else? It is your duty of the
Lordship-
public prosecutor who is conducting the case in the trial court.
You know. Obviously, CS already before the court.
When is the CS was filed?
My lord, 28th of October.
28th of October.
October 2020.
So now when May? No, till date, no charge sheet. What is the next date? 16th May?
Next date is 16th of May.
For what?
For again for production. Only
Production,
for-
no supply of
No
copy.
supply of copy, my lord. E-court status is there, my lord.
Which court?
My lord, additional sessions, just first court Jalpaiguri.
My lord, so far the case is concerned, my lord, prosecution has properly done, lordships, and that there is no laches and lacunae, ambiguity, nothing. And that has earlier bail application has been turned down by your coordinate bench on the lordship 17 December 24.
On another accused, not.
Yes,
Not.
both are standing in the same footing,
Yes.
joint positions, my lord.
Hmm.
Huge quantity of contraventions, my lord, 37 bar, my lord.
So I am passing a conditional order. On the next date, if you fail to supply the copy and within 15 days, if you will not fail to frame the charges and next 1 month you have not started the witness, he be at liberty to depart bail.
My lord, may I?
Now the High Court has to do all these things.
Yes, obviously, lordship. It has power.
May I, my lord?
See,
My lord,
this is
another
very-
thing is, another important thing is the persons who was shown as the independent witness in the FIR, their name is completely missing in the charge sheet as witness.
It is good to you.
No, no,
It is
Not
not
a wrong
matter.
for the
Yes,
bill.
my lord.
It is good to your defense.
My lord, the violation, this is a serious violation, my lord.
Not violation.
My lord, without independent witness,
Huh?
the charge sheet was filed. And it is, it is also on behalf of me, but it's a good liberty for me in the trial stage
Hmm.
that their name was missing in the charge sheet.
Hmm.
But it is the duty of the concerned IO to put their name in the charge sheet, my lord. And another thing.
See, the investigating officer will not do mistake. How you will get the acquittal?
It's not serious.
My lord,
And we are facing the emergency situation.
my lord, on the ground, on my detention ground, I am submitting one judgment.
This detention can come over by the 37.
My lord,
Satisfy me, I will
yes.
grant bail.
my lord,
Detention will satisfy the 37, then I will.
my lord, actually, there is a judgment passed by the landed appeals court, Ravi Prakash versus State of Odisha. My lord, in the second page, para number 4, it was clearly mentioned that in the last line, the conditional liberty must override the statutory embargo created under section 37.
Correct, I am telling that.
And my
The
lord-
statutory right, what is statutory right? If any violation has been made with regard to non-supply of the copy and not proceeded with the trial, what is statutory right?
My lord, and I am submitting another judgment passed by the Justice Jamal.
How many days you are inside custody for? How many days? How many? 380 days.
10,000 copies of it.
Maybe.
Quantity is huge, my lord.
More than 1 year,
And-
my lord.
Earlier occasions, they have taken the plea that sending the effects and all the consider.
On earlier occasion, I think rule 40 was there.
So suffering for the petitioner. So suffering for the state. The petitioner has filed the present application under section 483 of BNSS 2023, praying for bail. There were petitioners, both two petitioners or one petitioner? Petitioner,
Yeah.
single.
Here Monjit and another is Lordship's
Item number 8 is Manjit Singh and item number 2 is
Hardeep Singh.
Bail in connection with New Jalpaiguri PS case crime number 423 of 2024, dated 423 of 2024, dated 5th May 2024, under section 21 within bracket small c /25/28/29 of the NDPS Act, pending before the learned additional session judge, first court, Jalpaiguri, being NDPS case number 28 of 2024. 2020. Learned counsel for the petition submit that the petitioners have been falsely, and the petitioner have been falsely implicated in the present case. He submitted that since the arrest, the petitioner is in custody. But till date, the is in custody, full stop. Though the investigation has been completed and filed the charge sheet, but till date, charge sheet has not been supplied. Full stop. Counsel for the petition submitted, the petitioner is in legal custody for the last more than 380 days.
380.
380 days. Full stop. He submits that. That there, how many witnesses in the charge sheet?
15 witnesses.
He submitted altogether 15 witnesses have been cited in the charge sheet. And there is no, and in the charge sheet, there is no independent witness with regard to the inventory of the, with regard to seizure. With regard to the seizure of the alleged contrabands. And as such, there is no chance of the prosecution to prove the case against the petitioner. And as such, the petitioner is entitled to get the bail. Per contra, former learned counsel for the petitioner, counsel for the state raised objection and submit that. How many, what is the quantity?
10,000
10,000
bottles of cough syrup.
bottles of cough syrup have been seized from from the joint possession of this petitioner and the co-accused and during the investigation, it has been prima facie proved that this petitioners, this petitioner along with the co-accused are involved in the matter, and the petitioner has not made out any case to come out from the provisions of section 37 of the NDPS Act, and as such, it rate for rejection of bail. And the learned counsel for the respective parties peruse the materials on record. The petitioner has filed the present application for grant of bail on two primarily condition that the petitioner is in custody for the last more than 380 days. And in the charge sheet, there is no independent witness with regard to the seizure of the alleged narcotics and till date charge sheet has not been submitted, due to which the petition is languishing in the correctional home. Languishing in the correctional home. Full stop. Consider in full stop. This could find that 10,000 bottle of cough syrup have been seized in the joint possession of the petitioner and the co-accused, and the police has already completed the investigation and filed the charge sheet. Thus, this court did not find any, and thus this citizen filed the charge sheet. This court find that the petitioner has not come out from the section from the provisions of section 37 of this NDPS Act. In view of the above, this court is not inclined to grant bail to the petitioner at this stage. Accordingly, CRM NDPS number 116 of 2025 is dismissed. Full stop. Subpara. However, full stop. And the learned special judge.
Yes, special judge.
Learned special judge NDPS court within bracket additional sessions judge first court Jalpaiguri is directed to immediately supply the copy of the charge sheet to the petitioner on the next date fix and is requested to expedite the
Actually, item number already passed over, same matter.
Expedite the trial. Okay. Yes.
Pass over matter, item number 2, same matter.
This order na same in item number 2. दो order हो जाएगा. Item number 2.
One is Hardeep Singh and another
देख लेना नाम. Item number 2 का file भी दे देना उसके साथ. Yes, next.
Item number 9.
Here in this case, I am praying for bail on the ground of parity, Lordship. The co-accused is enlarged on bail on 28th of April 2020.
Where is the bail order
Lordship,
of the co-accused?
Give me a copy. Give me a copy. I want to see.
Pradeep Sarkar. And you are? Sudeep? Sudeep Das. What is your role?
Lordship, I was sitting beside him. He was the driver and I was sitting in that pickup.
To whom the materials were seized?
The medical was seized from the vehicle.
No. From Caesar ma'am who was signed? Your client?
By both.
Both. So why the Pradeep was granted bail?
Well,
Because
I
of the
have not
driver.
seen the order sheet. May I have it
Just
just
let me go through.
Delay in trial, Lordship.
Delay in trial.
Lordship.
Violation of 22(1) of the Constitution of India.
I'm in custody for 592 days, Lordship.
Why you not moved this application before the same court?
Both the advocates are separate, Lordship.
Better to take next circuit.
Lordship, kindly, Lordship, I'm already in 592 days, Lordship. And
Otherwise, contradictory judgment will be there. because I cannot pass this judgment. You have gone through my judgment in the full bench. That's why, if you want,
No, Lordship, tell me, Lordship.
next
See,
circuit.
Caesar has been judgment having
As
gone
per the
through that.
prayer, as per the prayer made by the counsel for the petition, let the matter before the next circuit bench.
আমাকে bail order টা দিয়ে দে কম্পিউটার
Yes.
My lord, for the petition in the matter, the matter is under the provisions of NDPS Act. Now, my lord, I am not on the merits of the case, my lord. I am on violation of Article 22, Sub-Article 1 of the Constitution of India, but which the Honorable Supreme Court has held that if there is any infringement of the fundamental rights under Article 22, that will vitiate the arrest. And even for a second, Lord, the accused cannot be kept.
What is vitiated here?
Lordship,
What right the police has infringed?
Lord, the
What
grounds of
is your
arrest,
right infringed by the police here?
Lord, the grounds of arrest has not been supplied to me.
Okay.
Now, my lord, I'll be referring to. Lord, I'll be referring to the Constitution once. Lord, should I take up the Constitution? Article 20. Lord, it is not only in NDPS, Lord, any special statute having statutory restrictions on bail, Lord, even on all those statutes, Lord, this fundamental right, Lord, is applicable, and if there is any violation, Lord, the statutory restriction cannot fetter my right to bail. That is
So,
not what.
when the earlier application was dismissed, when you filed the earlier
That time,
application,
Lord, this ground was never taken.
not taken.
Not taken.
Yes, now this ground has come.
It was not taken that time, Lord.
Yes, then,
Lord, taking your lordship to Article 22, Lord, kindly take up the Constitution.
yeah, constitution. Yes,
Now, my lord, Article 22, Sub-Article 1 says, no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Now, my lord, Article 22, this is the Lord, Constitution is the mother of all laws. Now, my lord, this provision has been incorporated in different penal statutes, my lord. My lord, may take up NDPS Act now.
yes,
Lord, we take up 52, section 52.
yes, yes,
Lord, 52 subsection 1 says, any officer arresting a person under section 41, section 42, section 43 or section 44 shall, as soon as may be, inform him of the grounds of such arrest. So, my lord, this comes from Article 22 of the Constitution of India. Now, my lord, I will take up one more act, Lord, the PMLA Act. My lord,
yes,
my lord, may take my book, Lord. PMLA Act.
yes, which section?
Section 19, subsection 1.
Yes,
Where it says, if the director, deputy director, assistant director, or any other officer authorized in this behalf by the central government by general or special order has on the basis of material in his possession reason to believe, that reason for such belief to be recorded in writing, that any person has been guilty of an offense punishable under this act, he may arrest such person and shall, as soon as may be, inform him of the grounds for such arrest.
yes,
My lord, may take up 45 also, my lord, PMLA 45. That is pari materia to section 37 of the NDPS Act.
yes,
My lord, it says, notwithstanding anything contained in the Code of Criminal Procedure 1973, no person accused of an offense under this act shall be released on bail or on his own bond unless the public prosecutor has been given an opportunity to oppose the application for such release, and where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any offense while on bail.
Yes.
So, my lord, this is exactly similar to the provision section 37 of the NDPS.
Correct.
Now, my lord, take up one more act, my lord, the UAP Act. Lord, may take up section 43, capital B. capital B.
Yes.
Now it says any officer arresting a person under section 43, capital A shall, as soon as may be, inform him of the grounds for such arrest. So, my lord, this is similar to 52 NDPS Act
Yes.
and 19 PML Act.
Yes.
Now, my lord, take up 43, capital D, subsection 5.
Yes.
Lord, next page, lordship will find.
Which section?
43, capital D, subsection 5. Lord, this is pari material with section 37 again. Notwithstanding anything contained in the code, no person accused of an offence punishable under chapter 4 and 6 of this act shall, if in custody, be released on bail or on his own bond unless the public prosecutor has been given an opportunity of being heard on the application for such release, provided that such accused person shall not be released on bail or on his own bond if the court, on a perusal of the case diary or the report made under section 173 of the code, is of the opinion that there are reasonable grounds for believing the accusation against such person is prima facie true. So, my lord, 37 NDPS Act, 45 PMLA Act, and 43D subsection 5 of UAP Act. My lord, one more section, next section, subsection 6. The restrictions on granting of bail specified in subsection 5 is in addition to the restrictions under the code or any other law for the time being in force on granting of bail. My lord, another section, next one, subsection 7. Notwithstanding anything contained in subsection 5 and 6, no bail shall be granted to a person accused of an offence punishable under this act if he is not an Indian citizen and has entered the country unauthorizedly or illegally, except in very exceptional circumstances and for reasons to be recorded in writing. So, my lord, these provisions are in addition to section 43D, subsection 5. So, my lord, from this, my lord, it can be inferred that the provisions of UAPA Act are far more stringent than NDPS and PML Act. Now, my lord, under this backdrop, I will be referring to a judgment of the Honorable Supreme Court.
Yes.
Lord, may take up paragraphs from paragraph 16 onward, page 22. Lord, a previous judgment of the Supreme Court has been referred to, and thereafter this analysis, Lord, starts from 16.
Yes.
Upon careful perusal of the statutory provisions reproduced supra, we find that there is no significant difference in the language employed in section 19(1) PMLA and section 43(b)(1) UAPA, which can persuade us to take a view that the interpretation of the phrase "inform him of the grounds for such arrest made by this court in Pankaj Bansal" should not be applied to an accused arrested under the provisions of the UAPA. We find that the provision regarding the communication of the grounds of arrest to a person arrested contained in section 43(b)(1) UAPA is verbatim the same as that in section 19(1) PMLA. The contention advanced by the learned ASG that there are some variations in the overall provisions contained in section 19 PMLA and section 43A and 43B UAPA would not have any impact on the statutory mandate requiring the arresting officer to inform the grounds of arrest to the person arrested under section 43(b)(1) UAPA at the earliest, because as stated above, the requirements to communicate the grounds of arrest is the same in both the statutes. As a matter of fact, both the provisions find their source in the constitutional safeguard provided under Article 22(1) of the Constitution of India. Hence, applying the golden rules of interpretation, the provisions which lay down a very important constitutional safeguard to a person arrested on charges of committing an offence either under the PMLA or under the UAPA have to be uniformly construed and applied. Next, Lord, 18. We may note that the modified application of section 167 CRPC is also common to both the statutes. Thus, we have no hesitation in holding that the interpretation of statutory mandate laid down by this court in Pankaj Bansal on the aspect of informing the arrested person the grounds of arrest in writing has to be applied pari passu to a person arrested in a case registered under the provisions of UAP Act. Resultantly, there is no doubt in the mind of the court that any person arrested for allegation of commission of offence under the provision of UAPA or for that matter any other offences has a fundamental and a statutory right to be informed about the grounds of arrest in writing, and a copy of such written grounds of arrest have to be furnished to the arrested person as a matter of course and without exception at the earliest. The purpose of informing the arrested person the ground of arrest is salutary and sacrosanct, inasmuch as this information would be the only effective means for the arrested person to consult his advocate, oppose the police custody remand, and to seek bail. Any other interpretation would tantamount to diluting the sanctity of the fundamental right guaranteed under Article 22(1) of the Constitution of India. The right to life and personal liberty is the most sacrosanct fundamental right guaranteed under Article 20, 21, and 22 of the Constitution of India. Any attempt to encroach upon this fundamental right has been frowned upon by this court in a catenary of decisions. In this regard, we may refer to the following observations made by this court in Roy V.D. versus State of Kerala, reported in so and so. The life and liberty of an individual is so sacrosanct that it cannot be allowed to be interfered with except under the authority of law. It is a principle which has been recognized and applied in all civilized countries. In our Constitution, Article 21 guarantees protection of life and personal liberty, not only to the citizens of India, but also to aliens. Thus, any attempt to violate such fundamental right guaranteed by Article 20, 21, and 22 of the Constitution of India would have to be dealt with strictly. The right to be informed about the grounds of arrest flows from Article 22(1) of the Constitution of India, and any infringement of this fundamental right would vitiate the process of arrest and remand. Mere fact that charge sheet has been filed in the matter would not validate the illegality and the unconstitutionality committed at the time of arresting the accused and the grant of initial police custody remand to the accused. Now, we'll at next page.
Yes.
Yes, Milord may take up 37 para. Next, that is in page 27. Milord, para 37 says the interpretation given by the learned single judge, Milord, that is the High Court judge, that the grounds of arrest were conveyed to the accused in writing vide the arrest memo is unacceptable on the face of the record because the arrest memo does not indicate the grounds of arrest being incorporated in the said document. Column 9 of the arrest memo, which is being reproduced herein below, simply sets out the reasons for arrest, which are formal in nature and can be generally attributed to any person arrested on accusation of an offense, whereas the grounds of arrest would be personal in nature and specific to the person arrested. Next, Milord, the reasons of arrest, Milord, is given normally, which was there in the previous case. Next, Milord, page para 40. Next page. We may, however, briefly mention that the grounds of arrest as conveyed to the advocate are more or less a narration of the facts picked up from the FIR, which in itself does not indicate any particular incident or event which gave rise to the alleged offense. However, the law is well settled that the FIR is not an encyclopedia and is registered just to set the process of criminal justice in motion. The investigating officer has the power to investigate the matter and collect all relevant material which would form the basis of filing the charge sheet in the court concerned. Now, Milord, the court, next para 43, the court did not enter into the merits of the case. We do not feel persuaded to examine these aspects at this stage because the same would require entering into the merits of the case. This would be within the domain of the court examining the matter after the filing of the charge sheet. The core issue in this appeal is regarding the illegality of the process whereby the appellant was arrested and remanded to police custody, which does not require examining the merits of the case. Now, Milord, para 45, that is the reasoning. We are of the firm opinion that once this court has interpreted the provisions of the statute in context to the constitutional scheme and has laid down that the grounds of arrest have to be conveyed to the accused in writing expeditiously, the said ratio becomes the law of the land, binding on all the courts in the country by virtue of Article 141 of the Constitution of India. Now coming to the aspect as to whether the grounds of arrest were actually conveyed to the appellant in writing before he was remanded to the custody of the investigating officer. We have carefully perused the arrest memo and the findings that the same nowhere conveys the grounds on which the accused was being arrested. The arrest memo is simply a pro forma indicating the formal reasons for which the accused was being arrested. It may be reiterated at the cost of repetition that there is significant difference in the phrase reasons for arrest and grounds of arrest. The reasons for arrest, as indicated in the arrest memo, are purely formal parameters. That is, to prevent the accused person from committing any further offense, for proper investigation of the offense, to prevent the accused person from causing the evidence of the offense to disappear or tampering with such evidence in any manner, to prevent the arrested person for making inducement, threat, or promise to any person acquainted with the facts of the case, so as to dissuade him from disclosing such facts to the court or to the investigating officer. These reasons would commonly apply to any person arrested on charge of a crime, whereas the grounds of arrest would be required to contain all such details in hand of the investigating officer which necessitated the arrest of the accused. Simultaneously, the grounds of arrest informed in writing must convey to the arrested accused all the basic facts on which he was being arrested, so as to provide him an opportunity to defending himself against the custodial remand and to seek bail. Thus, the grounds of arrest would invariably be personal to the accused and cannot be equated with the reasons of arrest, which are mentioned. But from the detailed analysis made above, there is no hesitation in the mind of the court to reach to a conclusion that the copy of the remand application in the purported exercise of communication of grounds of arrest in writing was not provided to the appellant accused or his counsel before passing of the order of remand dated so and so, which vitiates the arrest and subsequent remand of the appellant. As a result, the appellant is entitled to a direction for release from custody by applying the ratio of the judgment rendered by this court in Pankaj Bansal. Accordingly, the arrest of the appellant followed by remand order dated so and so also the impugned order passed by the High Court of Delhi dated so are hereby declared to be invalid in the eye of law and are quashed and set aside. Though we would have been persuaded to direct the release of the appellant without requiring him to furnish bonds or security, but since charge sheet has been filed, we feel it appropriate to direct that the appellant shall be released from custody on furnishing bail bonds to the satisfaction of the trial court.
Yes.
So, Lord, this case was under the UAPA, which is much more stringent than Lord NDPS Act or the PMLA Act. And Lord, this is the ratio of the Honorable Supreme Court, Lord, so far as grounds of arrest is concerned and constitutional safeguard is concerned. Next, Lord, Pankaj Bansal, Lord, which has been referred in this judgment, that is under PMLA, Lord.
Yes.
Lord, may come to para 38 straight away.
38.
38. Lord.
Yes.
But it says in this regard,
Yes.
in this regard, we may note that Article 22(1) of the Constitution provides inter alia that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest. This being the fundamental right guaranteed to the arrested person, the mode of conveying information of the grounds of arrest must necessarily be meaningful so as to serve the intended purpose. It may be noted that Section 45 PMLA enables the person arrested under Section 19 thereof to seek release on bail, but it postulates that unless the twin conditions prescribed thereunder are satisfied, such a person would not be entitled to grant of bail. The twin conditions set out in the provisions are that, firstly, the court must be satisfied after giving an opportunity to the public prosecutor to oppose the application for release that there are reasonable grounds to believe that the arrested person is not guilty of the offense, and secondly, that he is not likely to commit any offense while on bail. To meet this requirement, it would be essential for the arrested person to be aware of the grounds on which the authorized officer arrested him or her under Section 19 and the basis for the officer's reason to believe that she is guilty of an offense punishable under the 2002 Act. It is only if the arrested person has knowledge of this fact that he would be in a position to plead and prove before the special court that there are grounds to believe that she is not guilty of such offense so as to avail the relief of bail. Therefore, communication of the grounds of arrest as mandated by Article 22(1) of the Constitution and Section 19 PMLA is meant to serve this higher purpose and must be given due importance.
Yes.
Next, Lord, 42. That being so,
Yes.
there is no valid reason as to why a copy of such written grounds of arrest should not be furnished to the arrested person as a matter of course and without exception. There are two primary reasons as to why this would be the advisable course of action to be followed as a matter of principle. Firstly, in the event such grounds of arrest are orally read out to the arrested person or read by such person with nothing further, and this fact is disputed in a given case, it may boil down to the word of the arrested person against the word of the authorized officer as to whether or not there is due and proper compliance in this regard. In the case on hand, that is the situation insofar as Basant Bansal is concerned, though ED claims that the witnesses were present and certified that the grounds of arrest were read out and explained to him in Hindi, that is neither here nor there, as he did not sign the document. Non-compliance in this regard would entail release of the accused person straight away as held in V. Senthil Balaji. Such a precarious situation is easily avoided, and the consequence thereof can be obviated very simply by furnishing the written grounds of arrest as recorded by the authorized officer in terms of section 19 PMLA to the arrested person under due acknowledgement, instead of leaving it to the debatable ipse dixit of the authorized officer. Next, my lord, the second reason as to why this would be the proper course to adopt is the constitutional objective underlying such information being given to the arrested person. Conveyance of this information is not only to apprise the arrested person of why she is being arrested, but also to enable such person to seek legal counsel and thereafter present a case before the court under section 1445 to seek release on bail, if he or she so chooses. In this regard, the grounds of arrest in V. Senthil Balaji are placed on record, and we find that the same run into as many as 6 pages. The grounds of arrest recorded in the case on hand in relation to Pankaj Bansal and Basant Bansal have not been produced before this court, but it was contended that they were produced at the time of remand. However, as already noted earlier, this did not serve the intended purpose. Further, in the event the grounds of arrest were equally voluminous, it would be well nigh impossible for either Pankaj Bansal or Basant Bansal to record and remember all that they had read or heard being read out for future recall, so as to avail legal remedies. More so, as a person who has just been arrested would not be in a calm and collected frame of mind and may be utterly incapable of remembering the contents of the grounds of arrest read by or read out to him or her. The very purpose of this constitutional and statutory protection would be rendered nugatory by permitting the authorities concerned to merely read out or permit reading of the grounds of arrest, irrespective of their length and detail, and claim due compliance with the constitutional requirement under Article 22(1) and statutory mandate under Article 19(1) of the PMLA. Now, 44, we may also note that the grounds of arrest recorded by the authorized officer in terms of 19(1) PMLA would be personal to the person who is arrested, and there should ordinarily be no risk of sensitive material being divulged therefrom, comprising the sanctity and integrity of the investigation. In the event any such sensitive material finds mention in such grounds of arrest recorded by the authorized officer, it would always be open to him to redact such sensitive portions in the document and furnish the edited copy of the grounds of arrest to the arrested person so as to safeguard the sanctity of the investigation. Next, my lord, on the above analysis, to give true meaning and purpose of the constitutional and statutory mandate of section 19(1) PMLA of informing the arrested person of the grounds of arrest, we hold that it would be necessary henceforth that a copy of such written grounds of arrest is furnished to the arrested person as a matter of course and without exception. The decision of the Delhi High Court in Moin Akhtar Qureshi and the Bombay High Court in Chhagan Chandrakant Bhujbal, which hold to the contrary, do not lay down the correct law. So, my lord, this is my lord the ratio in Pankaj Bansal, my lord, with the
When the accused persons have been produced before the court, the investigating officer forwarding the report along with the grounds. You have been represented by the accused, represented by the advocate.
yes,
Then
but my lord, the
What-
grounds
what?
of arrest.
that's why what the 4445 says. Because this is not with regard to the arrest warrant. With regard to when you have been produced, the investigating officer producing the forwarding report along with the contents, why the PC remand is required, why the judicial remand is required. And if the accused is been represented and accused is there, if it is not, then the application is to be served.
No.
I am recording that. I will record that.
Lord, it says that whenever the accused
Because
is-
you are taking time for the 1 hour, I will record all these things. I will decide this.
For the
Because
prosecution.
only citing all this judgment will not solve the purpose. Correct. This all the things we know Here you are raising question with regard to the arrest memo is there. With regard to the forwarding, it is not the case, the investigating officer not
Right.
forwarded and the magistrate has sent the judicial custody. It is not your case.
No, my lord, here it was not that the investigating officer has not forwarded. Investigating officer has forwarded the accused.
Only see 45.
Yes.
Did the 45.
In the case on hand, the admitted position as the ED's investigating officer merely read out or permitted
Yes.
reading of the grounds of arrest to the appellants and left it at that.
Yes.
Which is also disputed by the permitted reading of the grounds of arrest.
Correct.
My lord, in my case, my lord, there is not even reading of the grounds of arrest.
Why the forwarding?
Goods were recovered from his house.
Ground of-
Okay, show me forwarding is not the ground for the arrest. Show me judgment.
My lord, the thing is.
Show me.
Caesar arrest. These are all Caesar arrest. যেগুলো UAPA, PMLA, these are key.
My lord, in para 40.
Arrest, Caesar. India is a different Caesar.
But para 40.
40.
Para 140.
14.
Yes.
Yes.
But the requirement, thus the requirement of informing the person arrested of the grounds of arrest is not formality but a mandatory constitutional requirement.
Correct.
Article 22 is included in part 3 of the Constitution under the heading of fundamental rights.
Yes.
Thus, it is the fundamental right of every person arrested and detained in custody to be informed of the grounds of arrest as soon as possible.
Yes.
If the grounds of arrest are not informed
Hmm.
as soon as may be after the arrest, it would amount to violation of the fundamental right of the arrestee guaranteed under Article 22(1).
Yes.
It will also amount to depriving the arrestee of his liberty.
Yes.
The reason is that as provided in Article 21, no person can be deprived of his liberty except in accordance with the procedure established by law. The procedure established by law also includes what is provided in Article 21. Therefore, when a person is arrested without a warrant and the grounds of arrest are not informed to him as soon as may be after the arrest, it will amount to violation of his fundamental right guaranteed under Article 21. In a given case, the mandate of Article 22 is not followed while arresting a person or after arresting a person. It will also violate fundamental right to liberty guaranteed under Article 21 and the arrest will be rendered illegal. On the failure to comply with the requirement of informing grounds of arrest as soon as may be after the arrest is vitiated.
Yes.
Once the arrest is held to be vitiated, the person arrested cannot remain in custody even for a second.
Correct.
Next, Lord 16. An attempt was made by learned senior counsel appearing for the first respondent to argue that after his arrest, the appellant was repeatedly remanded to custody and now a charge sheet has been filed. His submission is that now the custody of the appellant is pursuant to the order taking cognizance passed on the charge sheet. Accepting such argument with great respect to the learned senior counsel will amount to completely nullifying Article 21 and 22 of the Constitution. Once it is held that arrest is unconstitutional due to violation of Article 22(1), the arrest itself is vitiated. Therefore, continued custody for such person based on orders of remand is also vitiated. Filing a charge sheet and an order of cognizance will not validate an arrest which is per se unconstitutional, being violative of Article 21 and 22(1) of the Constitution of India. We cannot tinker with the most important safeguards provided under Article 22. Now, we'll at para 21, that is the reasoning. Therefore, we conclude the requirement of informing a person arrested of the grounds of arrest is mandatory requirement of Article 22(1).
Yes.
And we'll at the last one, F. When a violation of Article 22 is established, it is the duty of the court to forthwith order the release of the accused.
Yes.
That will be a ground to grant bail even if statutory restrictions on the grant of bail exist.
Correct.
The statutory restrictions do not affect the power of the court to grant bail when the violation of Article 21 and 22 of the Constitution is
Yes.
established. Lord, based on these judgments, Lord, coordinate benches of this honorable court has also passed orders. That's your fixed term. Now, my lord, kindly take up that judgment also last paragraph. My lord, I have
Which
missed
one?
paragraph. My lord,
Which
the
one?
last one, Bihan Kumar, I have, Bihan Kumar, the last one.
Yes.
Last page of the thing. Let's sixth line from the bottom, from the top, last page,
Yes.
sixth line from the top. It starts from therefore.
Yes.
Therefore, the purpose of communicating the grounds of arrest to the detainee and in addition to his relatives as mentioned above is not merely a formality, but to enable the detained person to know the reasons for his arrest, but also to provide the necessary opportunity to him through his relatives, friends, or nominated person to secure his release at the earliest possible opportunity for actualizing the fundamental right to liberty and life as guaranteed under Article 21 of the Constitution. Hence, the requirement of communicating the grounds of arrest in writing is not only to the arrested person, but also to the friends, relatives, or such other persons as may be disclosed or nominated by the arrested person, so as to make the mandate of Article 22(1) of the Constitution meaningful and effective, failing which such arrest may be rendered illegal. But this is a very short judgment. I'll be delving only to 2 pages, 2 paragraphs. But para 2. Sorry, page 2. Page 2, paragraph 3. It starts from upon perusing.
Page 2.
Page 2, paragraph 3, my lord. It's not numbered. It starts from upon perusing.
Yes.
Upon perusing Annexure P3, we can see that what has been provided to the appellant is only a arrest memo in the prescribed format, which is meant to be given to the appellant by way of an intimation.
Correct.
It has been filled up with the name of the appellant along with the place of arrest. Additionally, it has been written that he has been arrested based on the statement of the co-accused.
Yes.
We are in agreement with the submission made by the learned senior counsel appealing for the appellant that the said arrest memo cannot be construed as grounds of arrest, as no other worthwhile particulars have been furnished to him. This being a clear non-compliance of the mandate under Section 50 of the Code, which has been introduced to give effect to Article 22(1) of the Constitution of India 1950, we are inclined to set aside the impugned judgment, particularly in light of the judgment rendered by this court reported as Probir Purkasta versus State of Delhi, reported in so and so. In such view of the matter, the impugned judgment stands set aside and the arrest of the appellant followed by the consequential remand order are also set aside.
Next.
Milord, this is our High Court judgment. Page 2, Milord. This is also not numbered, paragraph not numbered. Page 2.
Yes.
Second paragraph, without going into the merits.
Yes.
Without going into the merits of the case and adhering to the dictum of the Honorable Supreme Court in Probir Purkasta versus State of Delhi, reported in so and so, and Bihan Kumar versus State of Haryana, reported in so and so, wherein it has been held that the reasons of arrest and grounds of arrest are two separate entities, which are to be handed over in writing to the accused before his application for bail, is preferred pursuant to his arrest in the court of the learned magistrate.
Yes.
I am of the opinion that since the grounds of arrest in this case were not communicated to the present petitioner, not there are any documents to substantiate that the same was orally communicated and a general diary entry maintained regarding such communication being made available, or in alternative any document was furnished before the court at the time when such communication was made to the petitioner.
Yes.
I am of the view that the procedure for arrest so adopted by the investigating agency is illegal. Accordingly, the petitioner is entitled to be released on bail by the as decided by the learned trial court.
Correct.
Lord, this is also coordinate bench's judgment. Lord, dealing with all the judgments that I have cited, I'll be only referring to para 10. Para 10, page number 5.
Yes.
It says, the same principle was also followed in the subsequent judgments passed by the Honorable Apex Court. However, the ratio is that non-compliance of mandate under Section 52(1) of the Narcotic Drugs and Psychotropic Substances Act, which has been introduced to give effect to Article 22(1) of the Constitution of India. In such cases, the legislative hurdle of Section 37 of the NDPS Act cannot stand in the way of releasing the petitioner accused on bail. Considering all the facts and circumstances, no option is left to this court but to grant bail to the petitioner without going into the merit of the case.
Yes.
And thereafter, bail was granted. This was also NDPS case. And my lord, there are at least 16 judgments my lord passed by coordinate benches. I will not be referring all, troubling your lordship, but I will just be giving the copies to your so that.
If you persons wanted to argue the matter on the basis of the argument, why you are not coming with the spiral and compliance? This. The one and one you're putting here.
Compliance and copy
If
to us
you're
also to
coming
the
the-
prosecution.
It has to be given to the prosecution so that.
And
it
we shall,
complies.
because these are not mentioned in their, in their main petition, no
no
whisper about all these things, my
Correct.
lord. So without,
Get it made, my lord, and
When?
by-
Now the already you've taken 1 hour over.
my lord, I can put in a fresh.
You all persons are practicing in the high court, you don't know how if you wanted to argue the matter on merit, relying upon the judgment, how you have to place the judgment before the court.
compliance and copy to us and given as an
List of
opportunity.
dates, facts of the case, then this all the judgments. Yes, any further judgments?
My lord,
And you're relying upon the unreported judgment, you're serving the copy to the other side.
No, we did a compilation of all the judgments, my lord. So whatever it is, you make a compilation and give us a copy and which paragraphs you are relying on. Nilaj Kolol Acharya.
Yes.
my lord, para 10. It also appears that grounds of arrest has also not been informed and admittedly no recovery was made from the conscious possession of the accused petitioner herein. The petitioner is in custody for 270 days. Accordingly, relying upon the judgment of the Honorable Supreme Court in this judgment is not cited.
CD,
The petitioner has been enlarged on bail. My lord, this is the only one I'm giving and not submission of the other. But there are 16 other judgments that I have found of.
No, if you want to rely, no problem.
Let's say almost of similar language.
Okay, yes.
Well, only thing on the last occasion, a report was called for. Why there is delay in the trial, my lord. The thing is that several times bill application was filed and the CD was lying in the high court. So in that is the reasons the trial court could not proceed
CD
with,
was lying in the high court.
my lord, because
When the
bail petition was
bill
pending.
petition was how the CD was lying here?
Original.
What you are telling, sir?
This is the report, my lord, because report was called for,
Call this,
my lord.
How the original, see, once you file the charge sheet, with regard to the CD of the court has to go to the public prosecutor. And the IO will keep your,
I has brought this from this is the original sheet.
why he has got from the PP?
My lord, the case was pending. Every day it was coming in the list, my lord.
Sir, what is the procedure? You are the public prosecutor.
My lord, man, I am
Correct.
ready.
What is the procedure for filing the charge sheet after the investigation? What procedure your state of West Bengal has adopted?
No, once the charge sheet is filed, the CD is handed over to the PP.
Total. If
Total.
suppose that CD is misplaced, what will happen?
The certified copy is kept with the IO.
Correct.
Oh.
Certified, the IO has to start the
My lord.
investigation with the three
copies.
carbon copies.
One to the circle
One,
inspector.
after completion of the investigation, the original will go to the court. This will be forwarded
My
to
lord.
the public prosecutor. The second copy will remain with the investigating officer. Third will be go to the
Superior
circle office. So if the court has called for the report, the IO has to bring.
Now the original, at that time, the original CD was called for. All the original documents which are to be exhibited there in the CD, my lord. That's why the court could not proceed, my lord, the jurisdictional court. And moreover, my lord, in this matter, we need time, my lord, because we have to answer on the merit points of merits, my lord. So, and they have to file us, they have to supply us all the copies of the judgments which they have.
When you will argue?
My lord, the only one thing is, but can it be fixed on Wednesday, my lord,
So
21st?
where is the time?
Thing is that on
Then court
Saturday
has to
morning,
go
I'll be
through
going to Kolkata. I'll be back on Sunday. I have arbitration matter there. So
Court has to go through all the judgment.
Monday, it will be very, Tuesday, the POXO matters will be there.
Because that's why I'm finding you all persons are placing one order. That's why morning I have not accepted that judgment. One judgment, the court is passing an order.
On Wednesday, positively, it will, we will call the IO also.
Because now
Positively,
the matter has to be settled.
we'll
for
be
once.
filing a written notes also, my lord. It will be easier
The
for my
matter
lord
has to
also.
settle for once. Whether it
I'll
is-
file a written notes, my lord, also on this point, my lord. With along with, let them file the completion of the all the status.
if we'll go by this, none of the accused will be in custody.
That's true, my lord.
None of the accused
That
have
is
been
that's true,
custody.
my lord. But thing is, but NDPS Act, this is something post Caesar
No,
arrest.
that's why.
And whatever
no,
citations they have given on
no,
UPA Act.
You
my lord,
cannot say that. That's why he has given all the act.
all the acts,
He
that's
has-
why, because he has relied on those acts. The
Correct.
citations, he has relied on those acts. That's why first he has placed the acts. That's why he has, thereafter he has placed the citations.
With regard to the
Because he is relying on.
no, but that's it. With
Those are all
regard to-
pre-Caesar, these are all
the
pre-Caesar
point-
arrests.
No, the point of law, you cannot say, no, this is applicable to this is applicable to this. With regard, see, act might be different. But with regard to the procedure of arrest
it-
by the investigating
My lord,
officer-
once the in NDPS case, once they're apprehended, then they are said they said what is the reasons on verbally they are said. Then
Correct.
section 50 notices are served whether they want to be searched before the magistrate or the guided officer. So long after that seizure starts in presence of an officer or a magistrate, thereafter the question of memo of the arrest comes and then memo of arrest is prepared in presence of witnesses. So this is NDPS Act cannot be tallied with other acts of UOPA or the PMLA Act, my lord. It's totally different. Now regarding our constitution, this saying he is the mother, absolutely admitted. But section 52 is also not directory. It's settled 2001 Supreme Court. It's not direct.
Since when the CD was in the high, it is with the you only, not with the High Court. How the High Court, how the I was writing
He
the
has sent the CD on 8th of April 2025.
huh?
8th
No,
of
no.
April.
Can you see, with due respect, I am listening the
Excellent. Yes. Yes, my lord.
with due respect, I humble submission, I beg to report that the charge sheet was submitted after the completing the investigation. Charge sheet was also framed. Charge was also framed. On 8/4/2025 was fixed for deposition of the witness PW2. However, on 8/4, witness PW2 was not present. Accused Mubarak Sons was absent. Learned PP submitted that the case diary was lying in the circuit bench of Calcutta High Court.
The
Circuit bench of Calcutta High Court. Jalpaiguri. When?
8/4/25 he has sent the.
8/4/25.
My lord, only that day the case was fixed, just we have sent the CD, my lord, because it has to be sent 1 2 days earlier, my lord. And we have received it on 9th. On the top of it's written, received on 9th.
Okay, keep it. Yes, ma'am.
But two things, my learned friend has said.
He has not completed. Let it complete, then I will give the chance to a reply.
But-
This is not the.
But
hilarious.
we need time,
Let
but
it-
that's.
You completed, you want to argue the matter, I will argue, let it continue. In future, you should not say that this court
As-
does not allow you to
Right, my lord,
submit. You
as
want to
the-
argue, then
No,
the
no,
court.
has given me ample time.
I am having the habit to hear the persons.
As the,
Not, again, I am asking you. If you want to argue further, you argue.
But I'll give reply
Okay.
to his subject.
When?
Wednesday, my lord.
Then how the judgment can be
My lord, I'll
passed?
make a written note, my lord, it will be easier. for my
Written
lord.
note, but the court has to pass
My
it.
lord, only that's the reason
Days.
that I can show my
Come
tickets
on
also. Monday, Saturday morning, I'll be going to Kolkata, I'll be coming on Sunday evening, my lord.
Can you keep it on Tuesdays and other things,
Tuesday
my
the
lord?
POXO.
Then you will give reply. Then only 2 days remains. Last day our officers will pack to go to Calcutta. That is the problem in the circuit.
Both, sir.
And there is a vacation to where the file will carry. Tuesday? When you will back?
Sunday.
So come on Tuesday. But the Tuesday, NDPS कब है?
Monday.
Monday. Then Wednesday होगा. Okay, come on Wednesday. So and so appearing for the petitioner. So and so. Give all the judgment. Have you taken note of it? So and so appearing for the petitioner. So and so appearing for the state counsel for the petitioners concluded his argument. Police counsel for the state case for accordingly case is adjourned. Let the matter appear on 21.
Let us have.
Yes, next. Item number 67, who is appearing?
Lordship, I am for the petition and
I am appealing for the state, my lord.
Lord, this matter was dismissed for default
Yeah.
because at that time I was not present due to my illness, Lordship. So I
None
filed-
of us of the defendant on several calls. Even second call, you are not present.
Yes, on that day I was in Lordship, I was not present before the, that's why Lordship. This matter got dismissed for default and within the due time, Lordship, I have filed for the restoration application, Lordship.
Who is for the other side? Have you served?
Lordship, this is the affidavit of service.
একটু বলুন না বেতন পিছনে গিয়ে বলুন।
Who is appearing? You are appearing?
But I am appealing on behalf of the state, my lord.
What about the other?
Lordship, I have served, but they have not received the copy, Lordship, so it has been sent back, Lordship.
Written insufficient address.
Lordship, I have given the address as mentioned in the plaint, Lordship. Plaint of them, Lordship. Kindly come to page number 6 of my supplementary affidavit, Lordship. This is the address where from I got her address, Lordship. Kindly come to my supplementary affidavit, page number 6, Lordship.
Where is the supplementary affidavit?
This is the
Page number?
6, my lord.
The complaint case, the complaint case,
Lordship.
125.
125, Lordship. This is the address, Lordship. So they have written their address, Lordship. And now they are not receiving and showing that insufficient address, Lordship.
सुनाई नहीं आ रहा, बंद नहीं करवा सकते आवाज को?
আওয়াজটা কম করেন না।
Yes. So-and-so appearing for the petitioner. So-and-so appearing for the estate. Petitioner has filed the affidavit of service showing that the notice of the present application is sent to the opposite party number
2, Lordship.
2, but this on the same was written unserved with the endorsement insufficient address, but this court find that the notice was served to the opposite party number 1 on the same address. On the same address on the same address which the opposite party has mentioned in her maintenance application filed under section 125 of the CRPC. Police. The petitioner has filed the present application praying for recalling of the order passed by this court dated 3rd of April 2025, wherein the application filed by the CRR 303 of 2024 was dismissed for default. Consider the submission made by the counsel for the petitioner for use the application. This court find that the petitioner has shown sufficient cause why the petitioner has not appeared before the court on the date fixed. Accordingly, order dated so. Order dated 3rd April 2025 is recalled. Full stop. CRAN number so disposed of. CRR number 303 of 2024 is restored in its original file. Police. List the matter. List the CRR number so 19.
Good.
Next.
Number 68.
16.
Come for the statement.
Yes.
Restoration application.
Restoration. Where is the order? None appears on behalf of the petition. Second call, it appears the petition is not willing to,
My lord, same thing happened, my lord. to be very honest, my lord, Honorable Justice Vivas Ranjan, he tried for the hearings. Now intentionally, intentionally they have, but this is nothing but short for a.
CRM.
for-
CRM.
On that time,
Just a madam, this is a CRM. Why the CRM you want to restore? You filed in another
Right,
application.
Right, my lord.
CRM, what is the necessity of the CRM for restoration? So and so applying for the petition, so and so applying for the state. The petitioner has filed the present application praying for recalling of the order dated 3rd April 2025, wherein this court has dismissed the application filed by the petitioner being CRM within bracket NDPS 105/2025 for default. Full stop. This could find that the petitioner has not appeared on even on the second call. And this could also find that the application which the petitioner, which this court has dismissed for default is only for grant of bail under the NDPS Act. The petitioner has full stop. Full stop. In view of the above, this court is not inclined to restore the CRM number so and so. Accordingly, crime number so and so dismissed. Full stop. However, the petition is liberty to file fresh application for grant of bail if so advised.
ঠিক আছে, ভালো।
Number 69.
Get close.
69 my lord, and
None appears, no accommodation, let the matter go.
But I have the petitioner.
Yes.
But kindly come
What?
to my lord, the
What is the CR?
FIR. That is after
What do you
page
update for? Watching
washing.
of section?
My lord, after page 18, my lord, that is the certified copy of the FIR.
Yes.
Yes. But a completely a fictitious allegation. So far, my lord, the narratives of the
Yes.
but completely a fictitious allegation, my lord. That my lord, he gave me, my lord, a huge amount of money.
Hmm.
My lord, page 18, my lord, kindly have a look.
Hmm.
My lord, I am a, my lord, constable
Hmm.
in the police department, my lord.
Hmm.
My lord, this, my lord, acknowledgement shows that, my lord, on that very date that has been, my lord, included in the FIR, my lord, I was posted for my official duty elsewhere.
Hmm.
My lord, so far the, my lord, the written complaint is concerned, my lord, no address has been specifically mentioned, my lord, that where he has, my lord, gone
Now
to,
what?
my lord, claim the money. Nothing.
Only you, Constable Mazur Rahman.
Yes, my lord, and the petition.
And you are the petitioner. And it is
That is the
Mazur Rahman
official
deciding
petition.
sense present deciding sense few months ago on 3rd November 2023. Date of incident. Actually, my
No,
cousin brother namely
date of
sold
incident
the
is
land
not,
and collected the cash.
21st of October
We
2020.
got Mazur Rahman, former constable. We also know from earlier transport the goods carrier which was systems. Former constable means he is suspended or terminated.
No,
So,
is in service, my lord.
kindly-
All along.
We got Majubur Rahman, phone number so former constable of NGPPS. Earlier he was posted in NJP.
Yes, my lord, yes. That
We
is
also
where,
know
my lord,
from,
statement.
we have transported the goods carrier from Jalpaiguri. Majubur Rahman contacted us and told that we have some family issues and the father 6 months from use them. Give the rupees 30,000 to him. Down to 3 months. When he has given the amount. That is not a date.
My lord, the date they have been specifically mentioned is on 21st of October 2024. That is, my lord, the
Incident about
from the, my lord, bottom, my lord.
correct.
On
Con-
21st of March, this official requisition says that, my lord, on 21st of my lord, October, I was posted elsewhere, my lord, pertaining to my official duty. That is page 18. And so far the written complaint is concerned, my lord, where he has, my lord, gone to claim the money, no address has been specifically mentioned.
Hmm.
He has very tactfully, my lord, used this term that he has handed over 30 lakhs by cash, my lord. So that, my lord, no evidence, no, my lord, nothing could be produced.
So what is the section 316?
316, my lord, corresponding to 406 and 420 of the IPC, my lord.
Yes, then
316, 318 of BNS.
correct.
It's a completely, my lord, concocted story.
What is the stage of the investigation?
I have already, my lord, enlarged on bail.
What is the stage of
Copy
investigation?
has not been served on us.
Copy not, sir.
No, it is a motion
Motion
state.
state, my lord, sir.
My lord,
The charge sheet, the investigation is not yet completed. You come with an FIR and you have a document, you.
my lord, I have to take instruction that whether, my lord,
See.
charge sheet has been filed or not.
Correct. See, with regard to the document which page 18 you are relying upon,
Yes.
even 482, even 227, the court cannot go into the document of the defense.
Yes.
Court has to rely upon the document which the prosecution relied upon. Now the charge sheet is not been filed. Correct. You produce this if to the investigating officer, they will consider, they will
My
not
lord,
consider.
partly, my lord, direction so that I could serve the copy, my lord.
What?
To the de facto, my lord, to the de facto as well as to the
Why
state, my
is
lord.
all these things? Let you come, you are on bail. You come, go with the investigation, let the charge sheet file, the charge sheet file come with an application, I am done.
But when, my lord, on the face of the record, the FIR is itself concocted, my lord.
How can you say?
Then, my lord, let it be pending, my lord. Let me pass a direction so that I could serve the copy, my lord.
You file this,
Let the case diary be produced, my lord.
No,
you file these documents with a forwarding letter. If she
no.
refuses,
What
then
about
that
the
is
document
different.
reliable, you go and approach the investigating officer.
Serve the purpose.
But I will, my lord,
In the-
let
in
me
the
serve, my lord,
In the 482.
my lord, let them appear with the case diary, my lord.
For
Kindly.
what purpose should be solved? You tell me.
My lord, if on the face of the record, my lord, if it is
That's why you immediately after the FIR are coming with the 482 without waiting the charge sheet. Might be they may file a final report.
so, let the application be kept
Because
pending till
if-
the
because
charge
once
sheet is filed.
once the complaint has been lodged, it is the duty of the police to lodge register an FIR. Otherwise, you will come with an 226 police in action. The court has to pass an order, or you go to the 156(3). The court has to pass an order. So after the FIR, you cannot say immediately, and you got the bail.
Let the FIR itself is a, my lord, abuse of the process of the court that I may apply, my lord, the court.
You can apply, but the court has to see the material.
Then, my lord, my humble submission is, my lord, let the application be kept pending, my lord. Let them, my lord,
So
come
and so
with the
sense
case
appearing
diary.
for the petition, so and so appearing for the state. Full stop. Petitioner has filed the present application being present application for praying for quashing of the entire criminal proceeding of GR case number 533 5331 of 2024. Initiated by the police of PS. Which PS?
Lord, it's NGP PS, my lord.
Police of NGP police station, police of NJP police station, being FIR number 1084 of 2024, dated 23rd October 2024, under section 316 within bracket 2/318 within bracket 3 of the Bharatiya Nyaya Sanhita 2023, pending before the Learned Chief Magistrate Jalpaiguri, being GR case number 5331 of 2024. Police counsel for the petition submit that as per the FIR, submit that if on the face of the FIR, it reveals that no case has been made out, but in spite of the same, the petitioner, the police has initiated the case against the petitioner. Police counsel for the petitioner also relied upon the document issued by the police, Reserve Inspector of Police, and submit that from the said document on the alleged date of incident, the petitioner was on duty and the petitioner was on duty. And as such, no case has been made out. Police counsel for the petitioner, please submit that. What is no case has been made out, and accordingly praise for quashing of the proceeding initiated against the petitioner. Full stop. Per contra, under advocate appearing for the state submit that the only after initiation of the FIR, petitioner has filed the present application for quashing of the proceeding, but investigation is still going on. Full stop. Considering the submission made by the counsel for the respective parties, this court find that on the basis of the complaint made by the complainant, on the basis of the written complaint, the police has initiated an FIR and the case is at the stage of investigation and investigation has not yet been completed. Police. In view of the above, this court is not inclined to interfere with the investigation at this stage. Thus, CRR number 69 of 2025 is dismissed. However, the petition is liberty to take appropriate steps if so occasion arise after filing of the charge on completion of the
Lord,
investigation.
one injustice, my lord, just our appointment may be regularized, man. One line, my lord. The appointment may be regularized, otherwise LR will create a problem.
This application is disposed of at the stage of motion, but this on the request of this court, the learned public prosecutor had appeared and his appearance may be regularized.
Grateful, my lord.
Appearance may be regularized.
After the petitioner, right? So,
Yes.
one of the petitioner is a 73 years old person.
Yeah.
And he's suffering from numerous ailments, madam.
Hmm.
I have annexed the documents from page number 10 to page number 51 in my petition.
What you have prayed for here?
Washing.
Washing on the ground of the illness.
My lord, he is of such health, my lord, that every month he is going to a nursing home and getting admitted there.
Correct.
And he is not being able to, he is a bedridden person.
Correct.
My lord, from page number 52, annexure P2, my lord.
Hmm.
P2 is the valuation report,
Hmm.
which was given by the petitioner in the year 2015. my lord.
Hmm.
In this valuation report, my lord, in the page number 53,
Hmm.
point number 9, my lord, onwards.
Hmm.
Point number 9, it is written, these are the points which has especially given one reflection, my lord, that property tax which are paid or not, it can be only told, it can be only advised by the bank.
What is the case against you? What is the case against you?
My lordship, give me only 1 minute.
First you show the what is the case against you, then I will go to the document.
My lord, it is the my case is 406, 417, 420, 465.
Where is the complaint?
Complaint is certified copy of the complaint after page number 60, my lord. From page number 60, it is there.
Page number?
After page number 60, my lord, the
Certified copy.
Right.
These are order sheets.
Order sheet is there, my lord. After that, the FIR is also there, my lord. The written complaint is also there.
First information report. I would like to bring the fine notice.
My lord, if the,
Details of the complaint. IOC has given the complaint.
absolutely, my lord. If this-
Description of the accused Nagendra Shah. You are the Nagendra Shah.
No, my lord.
Ah.
This is my case. I am not Nagendra Shah.
Just a
Who
minute.
am I? I am the.
Who are you? What is your name?
My name is my lord Subrata Gangopadhyay. I am the valuer of the property.
Just a minute. Subrata Gangopadhyay is the valuer.
Right.
Correct. Then what is the
My lord,
complaint?
here it is expressly written in the written complaint also that the accused have wrongfully and fraudulently shown the different property to be mortgaged to the bank with a dishonest intention to collaboration with the occupant or dupe the said loan amount from the bank and cause loss to our bank. Thereby, they have committed the criminal offences of fraud, cheating, and dishonor, whatever. Now, my lord, what is my role? I am a valuer, my lord. Whether or not the document was, the deed was genuine or not, it is expressly given in the valuation report that has to be ascertained by the advocate impaneled for the bank, my lord. Most importantly, this particular complaint, the accused person is Nagendra Shah and not me, my lord.
Yes.
So only to shade away the responsibility.
So you are the valuer.
Absolutely.
Where is the valuer report?
Value page number 52 onwards, my lord.
52.
Yes, lord.
Yes.
My lord,
Valuation report.
in page number 53, my lord, point number 9.
Now let me see. Following documents have been produced. Title deed number 1, dated so and so, approved a building plan in favor of Srimati Savitri Karmaka. Fasra number so and so, holding so and so so and so. Based on the actual observation, particularly described. How you inspected the property and in presence of the owner of the property, Nagendra Shah.
So Nagendra Shah is the owner of the property, sir.
Is the property,
Yeah.
but as per the report, he is not a property.
My lord, Nagendra Shah is the owner of the property as per the information of the bank, my lord, when it was given to me in 2015.
You are, have you the value, conducted any value of the property, or you are the approved lawyer of the bank?
Searching.
My lord.
What, sir, I am telling the procedure. If valuer or advocate, panel advocate, if the bank is sending a document to you, request to you to give the value of the property, what is the duty of the valuer? What is the duty of the lawyer?
I am explaining that from page number 53 of my petition, my lord.
So
Yes. My
now,
lord.
then first come to the page 52.
Yes, my lord.
Come to the page 52.
52, my lord.
Last four I have inspected the property on 29/9/2015 in presence of the owner of the property. Correct. So he has gone to the property
Yes, my lord, physically.
physically. I have not direct or indirect valued further the information, the other details given about the annex to and our knowledge. So he had been to the property. So if he had been to the property before that, he could have been the record of rights and the sketch map of the
No, my lord,
property.
there is a small glitch in it.
Hmm.
That is what I am trying to explain, ma'am. I was given the duty to assess the value of the property.
Correct.
And the physical, whether it is physically present or not,
Correct.
whether that the person is there or not, this was the scope of my duty, my lord. Regarding whether the deed which is presented to the bank by the accused person, whether that deed is right or not, whether there is any encumbrance or not.
Correct. That is the matter of investigation. Go to the
Madam,
investigation.
let's, I mean, 53, the page number is point number 9. Whether property tax is paid or not, details only the bank's independent advocate can tell. Then whether legal encumbrances, if any, is there, the bank independent advocate can tell. Whether the property falls under point number 12, my lord. Whether the property falls under the Land Ceiling Act or not, only the bank's independent advocate can tell. But in the next page number 4 also, my lord. Whether the property can be taken possession by the bank in case of need without any litigation, only the bank's independent advocate can advise. It is expressly written in here. What was my job? My job was to assess the value of that physical property. My lord, in page number 60, my lord, I have also annexed the photographs of the property. My duty was to go see whether it is physically there or not, what can be the value as per the roads and everything. Regarding the title, encumbrances, whether the searching was done or not, it was the duty of the advocate impaneled with the bank, my lord, or not me.
If suppose, leave aside this value, leave aside the Nagendra Shah. You are the valuer of the property.
Absolutely.
And I am the borrower and Mr. PP is the bank.
But borrower is
Yes,
Nagendra Shah, my lord.
That's why I am here telling. I am a borrower, you are the valuer and he is the bank. He has requested you to put the value. You came to me to tell me to identify the building. I have gone to the court and this is my building. You value the property.
Right.
Or you
absolutely.
will see, show me document, show me your all the things, and if you have anything, then you have to go to the revenue authorities or the municipal authority to identify. Then you have to value the property. If I show this is the Taj Mahal, this is mine. Can you value the property of the Taj
This was
Mahal?
not in this case.
Sir,
This
I was the panel advocate of the bank for 20 years.
I understand.
Even I was a panel of State Bank of India.
I'm very
Malad,
upset
I'll
about
just,
it.
though I should be allowed to speak, Malad, only thing is that for valuation, Malad, for determining the market value of the property, first of all, certain things are there which depends. Number, the size of the road, where the place. For these, the Khatiyan number, the plot number has to be ascertained. Now, they were supplied with from the bank or the party, the deeds, copy of the deeds, everything. So now they have to identify the plot. Otherwise, how they can come to a conclusion regarding the valuation of the property?
What I propose, this is the documentary evidence. This has to be ascertained during the investigation. In the 482 or 227, this court cannot go into that. Well, let the investigation complete. What the police relying upon, then you can come with the application. And
Whether-
this is very
My lord,
difficult.
Whether his intention of, even if
Correct.
negligence, whether
Lord,
intentional negligence or not.
Connivance.
My lord, this case pertains to a situation where the documents were given to me by the bank itself. Page number 52, it is written where the following documents were produced for scrutiny. They gave me the bank, the documents. They took me to the location, the bank officials. They showed me the building, the owner. I have valued as per their advice. But regarding whether this document encumbrances.
Correct.
This is
That
not
all
my
the
part of
things
the
will
job.
go and tell to the police. Let your statement be recorded.
My lord,
My lord, he is a very
ascertained by
person.
the
He cannot get up from the bed only.
The
my lord.
police will come and record your statement. Police will come and record your statement. You are a bedridden and you give all the documents. Because at this stage, how the court can interfere into the 482, sir?
But
But
my
very difficult.
prima facie, I have nothing to do
No,
with this.
how prima facie?
My lord, in the complaint itself, it is written that I am the valuer.
Correct. That's why you are the valuer. Might be you are in connivance with the owner who has obtained the loan. You might be connivance. You know that this property is not, but connivance with the you have given the 40 lakhs rupees of the valuation.
But my lord, my valuation was
But
right.
that has to be ascertained during the inquiry, investigation.
There is no objection as regards to my valuation. My lord,
So
kindly
for the
considers. My lord, kindly considers that the point. My lord, he is a bedridden person, has nothing to do with not even.
for the petitioner.
I may be at
The
least protected
petitioner.
from the.
You have been granted bail.
My lord, from 2022, when this case was initiated, my lord, I have given the documents in my.
You have been granted bail or not?
From 2022, I am on bed.
Then
I am on
So
bed,
what
my lord,
what-
not on bail, man.
Huh?
I am on bed, man. I am
You're not. You have been granted bail or not?
No, man.
They have not applied for.
You are not applied for.
Anticipatory bail was applied before the district court. my
Ah,
lord.
then what has happened?
My lord, I have to get back to with this information.
What?
Whether bail was obtained or not.
That is differently.
But I may be protected from the actions of police. My lord, I am really bedridden. I have given the documents to substantiate that as well.
Sir, if you are on bail, what the police will do? And if you are bedridden, you go to the court and apply for the bail if you are not applied for the bail. But 482 court cannot give any protection under the for grant bail. 482 the court cannot grant bail, sir. Suffering for the state. The petitioner has filed the present application under section 528 of the Bharatiya Nagrik Suraksha Samhita 2023. Praying for quashing of the entire proceeding pertaining to Siliguri PS case number 127 of 2022 under section 406/417/420/465/468/471 and 120B of the Indian Penal Code pending before the learned Chief Judicial Magistrate of Siliguri being GR case number 462 of 2022. Counsel for the petitioner submit that the petitioner is a approved valuer of the Indian versus bank.
Right.
Approved valuer of the Indian Overseas Bank Siliguri branch, and as per the request of the bank, the petitioner has valued the property of the co-accused, and on the basis of the same, the bank has.
My lord, I am not named as a co-accused in the FIR also, my lord.
So-
But this will all make stringent, my lord, this.
So why you have forwarded? Why you filed the application? You are not the named accused.
In the written complaint.
apprehension, he is apprehend that who is he is himself declared
Last week.
his involvement, my lord.
How?
The petitioner has valued the property or
Petitioner is the valuer, is the approved valuer of the bank, Indian Overseas Bank, and as per the request of the bank, the petitioner has provided the value of the property of one Mr. Nagendra Shah to obtain loan from the bank. Now the bank has initiated a case, has made a written complaint against Nagendra Shah as well as against the petitioner. And the petitioner submit that the petitioner is no way connected with the present case as the petitioner being the valuer, approved valuer, after identifying the property in question by the Nagendra Shaha and the bank authorities, comma, after valuing the property, comma, the petitioner has submitted the value to the bank. And as such, the proceeding initiated against the petitioner is required to be quashed. The petitioner has taken further ground that the petitioner is 70
3 years old.
3 years old and suffering from various ailments and is bedridden. And due to the instant complaint made by the bank, comma, the petitioner is suffering very badly. Good. Per contra, learned counsel appearing for the state submit that as per the complaint received from the bank, comma, the police has initiated an FIR and investigation is going on. Full stop. The complaint made by the bank is totally based upon the documentary evidence. And unless and until the charge sheet is not been submitted, it is not proper. It is not possible for the investigating officer with regard to the role of the present accused in the present case. And as such, he submit that the application filed by the petitioner is premature, as the investigation is still going on. Considering the above, this court find that at this stage it is not possible for the court to go to the merit of the case. Accordingly, CRR number 153 of 2025 is dismissed. However, the petitioner is liberty to file appropriate application before the appropriate stage.
Published.
Item number 71, I beg to appear for the petitioner. This in the revisional application, in order rejecting my prayer for interim maintenance is assailed before your lordship by way of this application.
Yes.
Your lordship, the petitioner is the married wife of the opposite party, and the marriage took place sometimes in 2017, and they were blessed with a child, and the parties are staying separately from January 2021. But thereafter, the opposite party husband have instituted a matrimonial suit for divorce. In the matrimonial suit, we preferred an application for maintenance. Initially, maintenance not being paid, we preferred an application, and the matrimonial suit, all further proceedings is being stayed. There is also a proceeding under Domestic Violation Act, Violence Act, maintenance allowed, not paid. But without any maintenance, we preferred this application, and an application was 125. An application was filed, an interim order rejected on the ground that as because there were earlier orders of maintenance, the learned magistrate, without considering that no maintenance is being paid, straightway in a mechanical manner rejected my prayer for interim application. If your lordship kindly comes to the impugned order, your lordship, the operating portion, may I just place it? The lordship will kindly seize. And I have annexed all the documents to show that in the matrimony.
Where is the impugned order?
Impugned order is the last one, certified copy. Your lordship.
Order dated?
Order is dated
7th April.
7th of April, yes, my lord. 7th April 2025.
Petition
Your lordship,
for your child in respect of the OP. According the petition and the daughter are found entitled to get maintenance from the OP. Now, from the documents submitted by the parties, this will find that the order of alimony pendant right of witness per month in favor of the petitioner is 17 of section 24 of the Marriage Act. And it night and another order interim for monetary relief passed in favor of the petition is custom night. Okay, so let us see. So you are getting the 25,000 plus.
my lord, that is where, my lord, this particular order, there has not been complied with. In the matrimonial suit, the order of alimony.
Sir, that order is not been complied with. You take appropriate step with regard.
Yes, my lord, the matrimonial suit is being stayed. All further proceedings of the matrimonial suit is being stayed. And my
Correct.
lord, yes, my lord, now I am without any maintenance. And my
Correct.
lord, the learned, your lordship, in the revisional application, I have annexed the orders passed in the matrimonial suit, which itself will shows that there was an order, but that has not been complied with. And as because the suit, matrimonial suit was filed by the husband opposite party, all further proceedings has been stayed. My lord,
Okay.
I am without any maintenance. And
Okay,
the
issue
learned,
noted. Okay, issue
my
noted.
lord, my lord, my lord.
So and so appearing for the petitioner. The petitioner has filed the present application, being agreed and dissatisfied with the order passed by the learned judicial magistrate second court Siliguri, Darjeeling, dated dated 7th April 2025 in MR number 133 of 2020,
133.
133 of 2021, wherein the London magistrate has refused to pass an order of interim maintenance as prayed for by the petitioner. Consider the submission made by the counsel for the petitioner. Peruse the impugn order. This court finds that the present revisional application is to be heard on merit. After heard on merit, accordingly, the petitioner is directed to serve notice upon the respondent. Both opposite party number only one.
My lord, only one, my lord, the husband.
Party and to file affidavit of service on the next date fixed. This is the matter before the next circuit bench.
Grateful lordship.
Next. Yes.
Lordship, in this application, the opposite party number 2 claiming herself as the legally married wife of the petitioner number 1.
Hmm.
And petitioner number.
What you have prayed for?
Lordship, I referred this application for quashing the FIR.
What is the stage of investigation?
Lordship, this case has been initiated on 4/4/2025.
So immediately after the FIR, you come before this court for quashing.
Lordship, this informant claiming herself as the wife of the petitioner number 1, she is not at all the wife of the petitioner number 1. I have annexed the document.
Correct, but that can be going to this court by in this application, revisional application.
Lordship, this informant has.
What is the case against you? What is the case? What is the offense?
Offense is the case has been started, Lordship, under section
85.
Yes, Lordship.
What is the 85?
498A previous.
So
she is not wife at all, my.
Okay. She is not a wife.
No, my wife is Lordship. I have annexed my document. Please see.
So how she is claiming?
Page number 17. This
so
is
how
the
she
registration
page number? Page number
17, Lordship. This is the marriage certificate of the petitioner number 1 with his legally married wife.
December 17.
17, Lordship.
Under Rule 6. Where is the photo?
At that time, this was not required, I think so.
Which year?
So 1995. Thereafter, I have two children, three children, 3 daughters.
Now your wife is there.
Yes, sir.
This wife is alive.
Yes, sir. And there's birth certificate of my children. That
So how she is claiming how the de facto complaint is claiming the wife?
Lordship, simply she stated that my husband see the FIR.
Yes, where is
certified copy of
what is
she
her name?
stated that she has not been maintained properly.
What is her name? Pratima Singh.
Pratima Singh. I have no nexus with this lady.
Pratima Singh. What is the complaint? What she has stated in the complaint?
She has not been maintained properly. She has not given any maintenance. And the petitioner number 1 is staying at Bangalore for his treatment for a long time.
So appearing for the petitioner. The petitioner has filed the present application, praying for washing of the proceeding initiated by the Pradhan Nagar Police Station, being case number 237 of 2025 dated 4/4/2025 under section 85 of the Bharatiya Nyaya Samhita 2023, pending before the Learned Additional Chief Judicial Magistrate of Siliguri. Police petition submits that the de facto complainant Srimati Pratima Singh and the de facto complainant who has lodged the complaint against the petitioner is not the wife of the petitioner. Counsel for the petitioner has relied upon certain documents which shows that the wife of the petitioner is, what is her name?
Omi Rai Singh.
Huh?
Omi Rai. OMI.
Srimati Omi Rai Singh. And the marriage between the petitioner and Srimati Omi Rai Singh is a registered marriage. And in the marriage between the petitioner and Omi Rai Singh, 2 children were born.
3.
3 children were born. But the de facto complainant has filed a false complaint claiming herself to be wife of the petitioner. Consider the submission made by the counsel for the petitioner. This court find that the petitioner has made out an arguable case and is to be heard on merit. Accordingly, the petition is directed to serve notice upon the opposite parties within a period of 2 weeks from date, and to file affidavit of service on the next date fix. Full stop. Let the matter appear before the next circuit bench.
No coercive measure
Full
will be
stop.
taken in the.
Pending disposal of the present application, the stay of the further proceedings of the criminal case. No, it isn't. The investigating agency are free to proceed with the investigation, but no coercive action can be taken
Lost.
against the petition.
Clear.
এখানে কিন্তু ব্যাকগ্রাউন্ড কিছু করে নেই না হ্যাঁ হ্যাঁ এখন শুধু ফর্মটা ফিল আপ করে জমা দিয়ে দাও না কিন্তু চলে যাবে হ্যাঁ এখন তো নম্বর তো দেখছি হ্যাঁ আমার এখানে আগে মানে বইটা তো এখন ব্যাপারটা যে সর্বোচ্চ উপর আইছে তুমি যে টাইপটা করছো না আমি যেটা আরো সহজ ব্যাপারে যে টাইপটা করছো ও ফিজিক্যাল মানে ওভার কি সমাজ আমি তো সাইড দেখাতে দেরি এখন একটা গ্রুপ খুলে গেছে ঠিক আছে কারণ আমি কিন্তু এখান থেকে টোটালি দেখা আমি কালকে কিছু সময় ওখানে কথা বলেছি কিছু কথা বলেছি আমাকে দুজনে বুঝলেন তো দুজনে আমার নাম লিখে দিয়ে দিয়েছিল আমাকে বললো যে দুজনে জামা পড়েনি এই যে দেখুন না তখন আমি বলি ঠিক আছে গিয়ে বলছি এখানে শেষ করে দেখি
ও কি পড়ে দিও
ওই যে
ফর্মটা নিজের দুজন ওদের দুজনের না আমাদের
না না আপনার দুজনে
কবে
কবে
আচ্ছা এই তো দীপেন্দু ভাই
ইয়ার করে না আচ্ছা আচ্ছা আচ্ছা
সুইমিং করলাম তার আগে সুইমিং করে ঠান্ডা হলো বডিটা তখন গিয়ে তুলে দিলাম আমার গরম লাগে না পরের দিন তো মানে খাওয়ার পর থেকে চলছে তারা अरे काली क्या আছে ভাই अरे काली ছিল কালি 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 জানিস না তোমার মুখ থেকেই শুনি দাঁড়া আমার আবার 2 নম্বর ভিতরে 26 নম্বর ম্যাটার আছে মানে এর মধ্যে কি দিবা এইগুলো তো করা দাও দাও কি করা তার মানে ভিডিও রেখে আর কিটা কমিশন যেগুলো পরের থেকে থাকে বল ওরা তো একসাথেই থাকে ছেলে কি করে
Yes. Huh? What is your prayer? Washing?
Dismissal order.
Washing?
Dismissal order.
What?
Dismissal default.
Dismiss in default?
Default.
What?
My lord, that applicable report should not appear to.
No, where is the CRAN? It is not a CRAN. It is a CRR 73. Where is the CRAN? What is your application for? It is the main application. So,
Not my lord, in the lower court, it is dismissed in default. You do mistake.
lower court dismissed for default. Now you came here. Why you not for what your complaint petition? You are the complainant. Where is the order? What is the order date? 2nd April, today is fixed for show cause by the complainant. Accused is present, complainant is taken no steps, show cause has been filed. None moves on behalf of the complainant on repeated call. Complainant has not been taken steps. Concerning conductor, it is presumed that the complainant is not interested to continue with the procedure as such. With no other alternative, let the record be dismissed for So why you come to High Court?
My lord, there are no jurisdiction to restore. The administration no jurisdiction in no material power to restore, to recall this order. I thought the public money, only default due to the mistake of lawyer, my lord, the lawyer, due to, mistake in the type. The amount is 4,05,500.
How this revisional application is maintainable before this court, sir? Why? Accused is discharge. Then what? Every money is public money. Sir, you filed the complaint case, you are not appeared. Correct, your complaint is dismissed for default. I don't know dismissed for default, what is the criminal. And your accused is discharge. If the accused is discharged, what is the remedy? Huh? Dismissal of the discharge of the accused is the to consult senior.
Actually not like, but in this case, your permission, this is not on merit.
Correct. So you file a revision before the district judge. How the 482 will lie here? 482, I already present. How the 482 will cause the proceeding? Yes.
Liberty to appropriate to appropriate.
Delegation, please kindly to set aside the order dated arising of so and so and so. Under section 18, the impending order deserves no merit and liable to be quashed, invoking the superintending power under section 4. When you file this application, 30 April. Under which section this application is filed? 482? Okay, issue notice, you have to face the consequence if the other side will come. You are not understanding the law. Concession suffering for the petitioner. The petitioner has filed the present revisional application against the order passed by the London GMF Judicial Magistrate First Court, Alipur Dwar, by an order dated 2nd April 2024, wherein the complaint filed by the petitioner is dismissed for default and the accused was discharged. The petition is directed to issue notice upon the opposite parties, opposite to the respondent, and to file affidavit service on the returnable date. Please the matter before the next circuit bench.
My application.
Yes.
But I am challenging the order dated 14 December 2023.
14 December?
2023.
Where is that?
It's certified for last.
You are appearing for husband?
Yes.
Petitioner wife does maintenance of it 10,000 per month for herself from the date of filing of the case.
There was past ex party. Subsequently, the execution case was started. And warrant of arrest was issued.
Correct.
Initially.
Correct.
I am unable to pay the amount. And then the police authority arrested. And I am suffered 1 month custody.
Correct.
After again, execution warrant was.
Naturally.
Kindly see, petitioner is a working
This is
lady.
not maintainable.
Petitioner is a working lady.
Maybe. So you
Tell
go
herself.
file under section 127.
Kindly stay the warrant.
No. This is a sir 125 ex parte order already, and this is of 20 when it was passed.
20th December.
You are not appeared before the court, and the court has passed an ex parte order 14 December 2023, and you have already suffered imprisonment for 1 month.
1 month.
1 month, and still you are not challenged. You are challenged before the High Court. Kindly, you are having the CRPC. Go through the 127.
But there is a petition to make an application.
Then?
Kindly stay the warrant.
Go there. How the execution case warrant will be stayed here? You have to pay until unless the order is not settled. You have to pay.
Section instead of no, I am working on the order date.
The warrant of arrest is issued.
I am ready to cooperate with the proceedings. But the last 2 occasions, the conducting law did not take any step for that ex party was.
Sir, unless until the order passed by the magistrate regarding grant of maintenance is not satisfied, you have to pay. Under what ground this court can stay the warrant? You have not paid. She has filed an application for execution. You have not appeared. You have not paid the maintenance amount. The court has issued this warrant. Then
I am not unable to pay them.
go and tell the magistrate.
And wife is the working lady.
Oh, so you have not taken steps when you came to know.
I came to know after marriage.
Then no, came to know about this maintenance order. First execution case was filed. Then you have not filed any application for for variation of the order. Yes, 127(2). What you want? So and so appearing for the petitioner, so and so appearing for the state. The petitioner has filed the present application. You are also challenging the maintenance order also. Filed in present application challenging the order passed by the Leonard Additional Chief Judicial Magistrate, Mcleganj, dated 14 December 2023, in miss case number 19 of 2023, wherein the London Magistrate passed an ex parte order directing the petitioner to pay an amount of rupees 10,000 per month, being the maintenance for the opposite party number 2 from the date of filing of the case, that is 24th August 2023. And the petitioner has also challenged the order passed by the London Magistrate in mis-execution case number 2 of 2024 by order number 12 dated 20 December 2024, wherein the London Magistrate has issued the warrant against the petitioner hearing. Had the London Council for the petitioner peruse the material, materials on record and the impugn order. This court find that the impugn order dated 14 December 2023, the London Magistrate has passed an ex parte order as the petitioner failed to appear in the said miss case, and subsequent to the order, the respondent wife, opposite party number 2 wife, had filed an application for execution, and the London Magistrate has and the petitioner, being the husband, has not paid the amount. Accordingly, the London Magistrate has issued the warrant of arrest. Full stop. This court find that warrant. Full stop. Considering the above, this court find that the present revisional application is not maintainable before this court, and the petitioner is having an alternative remedy. Accordingly, CRR number so and so 206 of 2025 dismissed. However, the dismissal of the present application will not prevent the petitioner for taking appropriate steps in accordance with.
Lordship, may I be audible?
Yes.
My lord, this is the criminal revision application for quashing or setting aside the order that is annexure number 46, dated 27/3/2025, passed by learned ADJ or ASJ, Additional Sessions Judge, Fast Track Court, Siliguri, in the criminal appeal number 22 of 2023, imposing a cost of rupees 5,000. My lord, I am an advocate as well as petitioner in person, appearing along with my colleague Advocate Devojit Kundu before your lordship. And may I be permitted, your lordship? Your lordship, I am an advocate as well as my mother, that is revisionist number 2 of the petitioner, revisionist number 1, myself, is suffering from a severe stroke, that is intracerebral hemorrhage and intraventricular stroke with dementia and cognitive impairment, and under critically ill coma condition since 16/5/2025, and is alive till date, my lord. And the doctor advised the patient to be kept under home care ICU, that is in my home, with an advice as annexed in the discharge certificate, annexure number 24 to 27, my lord. There you can, if you kindly come to that particular 24 27, in annexure number 25, in column number 24, the patient is on tracheostomy, and the tracheostomy site should be clean and dry, and the periodic suctions as and when needed 1 hourly, and change in even 7 days. This is the intricacies and no other competent person is there to take care, and no as because in such type of medical emergencies, because the revisionist itself himself is a doctor in pharmacy from Jalpaiguri University, and on that very date, and now also the mother's condition is too serious, between life and death. Finding no option, my lord, the petitioner filed a prayer before you for the adjournment, annexure number 28 to 29, my lord. There you can go, you can directly see that through the email to direct judge's email account, and also orally submitted through learned advocate advocate engaged over there, as he is residing at Balurghat, and Dakshin Dinajpur is about 400 kilometers from Siliguri, and it is not possible to attend the court on 27/3/2025.
But Mr.
According to
Mr. Advocate, this is an appeal. For appeal, where is the necessity of appearing of the person, appearing of the party in person? It is the advocate has to argue the matter. Your client,
myself, I am enrolled in High Court itself, my lord.
Correct. You are appearing in person, no problem, and you are taking the advantage of the medical treatment of your mother. But what is the appeal? What is the appeal?
Appeal is it is a domestic, it is against the domestic miscase, domestic violence miscase. Against that the appeal has been filed, and in that particular I could not appear, my lord, on that very particular day. My mother was too serious, and I have sent the video of that particular to that mail of the.
Okay, there's no problem. On the court has only given an what has happened on 3rd of May.
3rd of May.
3rd May, what has happened? Because the court was fixed on matter on 3rd May. What has happened on 3rd May?
The court was transferred, and similarly, it has been transferred to next date, my lord, on 8/7/2025.
You go and file, pay fine of because you're taking time. That's why the court has granted time.
It is my mother. If you kindly permit me, I can show that. I cannot go.
The court, the High Court cannot interfere in the revisional application. With
But
regard
this
to the cost.
discussion in that particular, my lord, if you kindly come to that, ground portions, that particularly these two, the Honorable Supreme Court has already, declared in that particular Dr. Vijay Malla, the Mrs. Vijay Manohar Award, and Kashiram Raja Sawai and others I have mentioned in that particular grounds itself. And in another case, that is Akam Ivodi versus Akam Virajwaja. In that particular, it is clearly, it is the duty of the son to take care at the last yesterday days, and she is now alive, my lord. If you can see, if you permit me kindly, I can go to the particular bed. She is just near to my chamber, just next to the. If you kindly permit me, I can show the status of that particular my mother. In that case, how it is possible?
Court is not going all the things. You have been allowed to appear through the virtual mode. It is not that I have to see the patient.
My lord, if you, I cannot, convince myself in that case. So, so what else I can do? Simultaneously, I have submitted the continuous medical treatment, the blood transfusion.
You tell me this code when you will be available. I will fix it here in now a date before the London court, so that you can go and argue the matter. Tell me which date you will.
Yes, that can also only be done on
new session judges.
My lord, how can I predict my mother's life, my lord? It is the life. It is, and you kindly give as is next date itself. Just only waive the cost, my lord. Only waive the cost. That's why. That's what my prayer. I can appear to virtual.
London Additional Session Judge, Fast Track Court, Siliguri, by order number 12 dated 27th of May 2025, wherein the London Additional Session Judge has allowed the application filed by the petitioner for adjournment, subject to payment of cost of rupees 5,000 to the respondent number 1. Full stop. Full stop. Counsel for the petitioner submit that the petitioner is a practicing advocate and his mother is seriously ill and totally bedridden and is continuous under medical treatment, and as such the petitioner, being the son, has to look after the mother, due to which the petitioner could not appear before the learned court and file an application for adjournment. But without considering the serious condition of the mother, the learned session judge has learned additional session judge has imposed while granting adjournment, imposed cost of rupees 5,000. Full stop. At the time of hearing, this court has this court asked the petitioner to specify the date when the petitioner will appear before the learned additional session judge to argue the appeal filed by the petitioner along with his mother, but the petitioner submit that he cannot suggest the date because due to the ill health of his mother. Considering the submission made by the counsel for the petition, this court find that the learned additional session judge, taking into consideration of the earlier dates, as the petitioner time and again has taken the time, accordingly, learned session judge is in its discretionary power has adjourned the case by imposing cost of rupees 5,000. Thus, this court did not find any illegality in the order passed by the learned judge by the order dated order number 12 dated 27 of March 2025. Accordingly, CRR numbers 207 of 2025 is dismissed.
That is 8 July. 8 July 2020.
Item number 76.
Only there is to waive the cost.
Court has taken lenient to you. You are arguing before the court. What can be done? Yes, who is my petitioner?
Yes, sir. Lordship, in this case, the petitioner before your lordship is the de facto complainant. What has happened on 19th of June 2022, the father and the brother of the petitioner, they were assaulted by opposite party number 225. Father of the petitioner was assaulted by a sharp cutting weapon and he suffered serious injury, lordship. Initially, case was started under section 341. 325, 307, 379, 34 of the Indian Penal Code. Subsequently, charge sheet was submitted under section 447, 323, 34 of the Indian Penal Code, showing that the injury is simple in nature. Now, lordship, if your lordship come to page 14 of my application, this is the CT scan report of the father of the petitioner. Kindly come to the last portion.
Multiple lunar infection of the left side of the brain.
Yes.
Stem of right side. Yes. What has happened there?
And,
so what you want?
Kindly see the next page. This is the rejection order of the anticipatory bail application of the opposite party number 225.
Opposite party number? You are the complainant.
I am the de facto complainant.
Yes.
Kindly see, this is the rejection order. Kindly see paragraph.
However, on perusal of the relevant record, medical report, FIR there to the extent injury, I do not think that this is a fit case for granting anticipatory bail.
Fifth paragraph, kindly see. Produce the materials on the case record, CD. Noted the injury, also produce the serious documents, as series of documents as submitted by the de facto complainant through state, wherefrom it appears that one Jabbar Ali is the father of the petitioner,
correct,
has been seriously injured on his person and was admitted in the hospital. Noted in the CT scan report dated 19/6/2022, which speaks.
Correct. Yes, no problem.
Now we should have filed an application from Naraji against the charge sheet.
So whether the final report is filed?
Charge sheet submitted under section 341, 323, 34.
Correct.
I have filed Naraji application. Naraji application was rejected, showing that as the injury is simple in nature, so it cannot be allowed. Can you see the order? This is a certified copy. Last page. Order dated 18th of March 2025.
whether addition of charge will be a Narazgi petition, further investigation.
Yes, sir. 178 subsection 8. Yes.
One 178
Subsection 8.
subsection
8.
one 173. Subsection 8. Nothing in section deemed to preclude for further investigation and respect the offence after the report has been forwarded. to magistrate.
173.
Huh?
173 subsection.
173?
Subsection 8.
That's why investigation of charge of the police obtain evidence on order or document and he shall forward the magistrate for a further report regarding the evidence in form and so. This document. This document which you are relied upon, that is seized by the police.
Yes, yes.
So what further investigation? If you want the addition
Because
of
the
charges, you can file an
Your
application.
Lordship, kindly see the charge sheet.
Where is the charge sheet?
Huh?
Where is the charge sheet?
Yes, Lordship. Charge sheet is from page 16. It is started from page 16. And page 18 is the relevant portion. Kindly see page 18.
18.
Yes.
Where is the document? List of documents. Where is the list of documents? Charge sheet containing list of, where is the list of documents in your charge sheet, sir?
The charge sheet is filed by them, Lordship.
So that's what I'm telling, where is the charge sheet? You file an application without going through this. If this document has already been received by the taken position by the investigating officer and it is the part of the charge sheet. So how the 311, how the Narazgi petition is maintainable?
No, Lordship. I'm asking for fresh further investigation.
For what? Only for the grievous injury?
Yes.
This is the 323. As per you're telling that in terms of.
Initially, case was under section 325, 300.
Correct. And you are relying upon this medical document.
Medical document and order of the session court.
Order of the sessions court. See, this anticipatory bail application, interim order, injunction order, that cannot concluded as a final hearing. You cannot take.
Passed after going through.
Yeah, that's why I'm telling whether the charge sheet, whether this has been taken, police has seized this document, made a part of the charge sheet. The document which you relied upon and which the honorable court has relied upon. Sorry. Bijan, तुम्हारा बोलो और लिखो आता लिखो अरे कोई को भेजो ना तुम क्यों जाते कोई नहीं है
Yes, Lordship, kindly see the page 18.
Page 18, yes.
I am skipping the first portion.
Yes.
Several raids were conducted to arrest the other accused, but in vain.
Yeah.
I also.
Who is appearing for the state?
I
Who is, you are appearing? You are having CD?
This is the first.
First. Whether this document is seized?
Saying that it has been seized.
No, yes, charge sheet, but the charge has not enclosed the other document. It is only a list of witness. Where is the document?
The copy has not been served out.
I also collect the injury report.
Collected the injury report. That's why, where is the injury report? That's why I wanted. What is there? But the height to see because where the call for. So when can you bring the CD? Which PS? Monday? So and so appearing for the petitioner, so and so appearing for the state, for the council for the, this court find that to, and this could find that for, and this could find that the CD is required in the matter. Accordingly, the council for the state is directed to bring the CD on 19th May 2020. This is the matter on 19th.
19.
Yes.
Thank you. 77, I appear for the petition.
Yes.
Lord,
Stand dismissed.
I must
Criminal appeal is dismissed.
Yes. I must candidly, my lord, submit that talks of settlement are going on with the complainant, which is why we have filed this revisional application for
Not settled.
not yet settled, my lord. We'll seek a short adjournment for a few days.
Oh, talks are going on. So when?
Next.
By this week it can be done. Next week it can be.
Number 5 of the main petition is not settled. Because of the party.
Okay, come.
Settled amongst the parties there.
Yes, it was.
As per the prayer made by the council for the respective parties, let the matter appear on 20 May. Next.
I can know of 78.
78.
Your Lordship, I beg to appear on the behalf of the petitioner.
Yes.
Your Lordship, the FIR has been registered under section 126/2. 126 again, everything is different pages. 115, 117, 76, 351.
Correct.
And subsequently, charge sheet has been submitted under 126, 115, 76, 51. Lordship, before going into the merit of the case, I want to share your Lordship the factual.
What you want? Quashing?
Question, Lordship.
Who are you?
I am the, there is a sole accused person.
You are the sole accused.
Yes,
Who is the complainant?
Complainants, Lordship, I want to share some factual backdrop before going into merit of the case, Lordship. Lordship, I along with my aged parents, I live in a flat resident and just above the de facto complaint team. Lordship, since 2023, when I purchased that flat, since they are demanding illegal money from me as a extortion or something like that. Since then, I made many representations before the police authority. Since 2023, I am complaining against them. And this case has been filed on repercussion of that. On same day, Lordship, I have also filed a complaint case. When my son, I'm the petitioner. When my son was entering, this petitioner was entering at home, the de facto complaint along with his husband, beaten this petitioner. And police, the aged parents of the petitioner called the police, and the police came. Police asked that we will take your son for a medical purpose. And on the same day, they put him behind the bars. Lordship, since 2023, I am complaining against this.
So what you want now?
Quashing.
How it can be caused?
Lordship, this case is completely nullified, Lordship.
So show me what are the ground for quashing. What are the ground for quashing?
They have given the section 76 for disrobing, and they have not made any seizure on this regard. No appearance has been seized, Lordship. And even they have put a section 351/3, which is rage for hurt of the grievous hurt, but the grievous hurt already been removed in subsequently in charge sheet.
No, charge sheet is filed under 351 with them at 126(2). What is the 126(2)?
Wrongful restraint.
Wrongful restraint.
351/subsection 3.
126 is the wrongful restraint.
Have not been served with a 41 notice also. On the same night, police took me for a medical purpose and put me behind the bar. Lordship. They have not served me 41 notice also. And I also my
41 notice of what purpose would you serve in during that is trial? That is over then
That is, on the same day, I have also, my aged parents also lodged a complaint against them.
What has
But
happened
no
to that?
corrective action has been taken against the.
So you take appropriate action when you made the complaint.
On same day, Lordship.
So what has happened to that complaint?
Lordship, it's now the trial is going on.
It is going on.
Charge sheet has been submitted recently. I have applied for the
So
certificate.
that is also both the case tagged together.
On that, I have made the complaint, Lordship.
Correct. You have made the complaint. That is also police has registered an FIR. Investigation is completed. Now they file the charge sheet. In against you also, your client, not you, against your client also, police has registered a case and investigation completed, file the charge sheet. So both are there. And against in that case, what is the section? Same.
Lordship, more or less same.
Then
Lordship, the thing is, I made a complaint against them, Lordship. Kindly come to the page. Thirty-three of my application, Lordship.
both the cases charge sheets, both the cases tagged.
After that, also I have also again lodged an FIR against them.
Huh.
I have complaining since 2023, Lordship.
Huh.
They filed this complaint only to harass me, Lord, nothing else. Lordship, can come to the page 24 of my application, Lordship. You can see, Lordship, that I have been complaining against the witness, which are in this case, the witness, the police have been recorded, Lordship. I have been complaining against them since.
Just a minute. 233. Yes.
Also, the witness, the police which have stated in this FIR, in charge sheet, I have complaining against them since 2020. Still, they are.
Sir, you show me the ground for quashing. What are the ground for quashing?
No seizure has been made.
No seizure has been made. That is the defense. Then
The witness which has been there is a 6 witness altogether with 1 PSI. All the witness they are. I am complaining against them since 2023. So this FIR has been lost as a repercussion of that. They have all three lost this FIR.
okay, you did a good defense. Then
But still they are harassing me with.
have you gone through the 482? For 482 for quashing of the FIR for the what are required?
The case.
You have to satisfy this, though, that no case is made out. Tell me what case is not made out.
Lordship,
No prima facie case is found in on the face of the record. Show me.
let me come back tomorrow.
Why? That's why every day this circuit bench list is going high and high. You file the 482.
Lordship.
You file the application. You don't know what are the ground.
Yeah, I'm stating that, Lordship. In section 76, only the main section is 76 on Lordship. No appraisal has been ceased, Lordship.
Correct. That is a benefit to you during the trial. Then
There are no independent.
126, what will happen to restraint? How you say there is no prima facie case? If the court will find you have restrained the person, then
Kindly make it not to that and come back tomorrow and satisfy, Lordship.
not today. Next.
79.
Little Mr. Obrozidas, he appearing virtual.
Lordship, in item number 79, I'm appearing actually.
Yes.
This is a case with a prayer for expeditious disposal of a petition and of domestic violence. Lordship, this petition was filed, this application before the lower court was filed in the year 2020, Lordship. And
2020, you are appearing the wife.
Yes, Lordship, yes. Lordship, in the meantime, there was COVID-19, so there was a little bit delay with respect to that. So this was out of the reach of the court actually, because court could not function properly.
Which court?
Judicial Magistrate, Third Court, Lordship, Siliguri.
Okay, then now after the March 2022, all the things are over. What has happened after March 2022?
Lordship, 2 times ex parte, it has been fixed for ex parte, 2 times it has been vacated, Lordship. Now, again, it is running ex parte, but we are anticipating again that there will be a delay in the year, Lordship. Now, as per section 12 of the Domestic Violence Act, Lordship, there is a specific provision for disposal within a span of, Lordship, in 12, every application needs to be disposed of within a span of 60 days from the date of filing, Lordship. It is in 12.5, Lordship, 12 subsection 5.
Yes.
Lordship, I am only harping this court on the prayer that there should be a order of disposal within a specific period, Lordship. That is my only prayer, Lordship.
When you filed, where is the first order? You have included the first order, no?
Yes, Lordship, it is there, Lordship.
Where is the order?
I'm showing, Lordship. It is in, Lordship. First order should be. Lordship, it is in. No, Lordship, I annexed it from 6/4/2023, Lordship. It is in page number 44. Page number 44, Lordship. No, Lordship, it is there. Page number 39, Lordship.
Yes, 39.
39.
This is the first, you have filed this.
Lordship.
When the opposite party appeared?
Opposite party appeared, Lordship. I think it is in 19/11/2022. Because there is a recording, Lordship. Complainant filed Sajira on his behalf and OP is absent by a petition.
You are appearing for? Nobody is there. Record. And so appearing for the petitioner. Police. The petitioner has filed the present application praying for a direction for expedition direction upon the London which court?
Judicial Magistrate, Third Court, Siliguri.
Upon the London Judicial Magistrate, First Court.
Third Court.
And now it is Third Court because seal is the First Court.
Lordship, it is Third Court, Lordship.
Judicial Magistrate, Third Court. Judicial Magistrate, First Class, Third Court, Siliguri. For क्या बोला? The
petitioner filed a present application free from rejection upon the language judicial magistrate first court
Siliguri for disposal of the application filed by the petitioner under section 12.
12, Lordship, 12.
Section 12 of the domestic protection of domestic protection of women from domestic violence act 2005 being miss case number 89 of 2020. Counsel for the petition submit that the petitioner has filed the application under section 12 of the domestic violence act on
28/9/2020.
On 28th of September 2020, but unfortunately due to the COVID-19, till 2022, matter could not be proceeded further. Subsequent, on 2 occasions, the matter was taken up for ex parte hearing, but subsequently the opposite party had appeared and the ex parte order was vacated. But till date, the case filed by the petitioner has not been disposed of. Counsel for the petition submit that as per the provisions of subsection 5 of section 12 of the Protection of Women from Domestic Violence Act 2005, the application filed by the petitioner under section 12 of the said act is to be disposed of within a period of 6 months.
60 days, Lordship.
Sorry, 60 days. Within a period of 60 days, but in the present case, the 5 years have been passed, but till date, the application filed by the petitioner has not been disposed. Considering the submission made by the counsel for the petitioner, peruse the materials on record. Admittedly, the petitioner has filed the complaint in the year 2020, but the set of complaint is still pending. In view of the above, the learned judicial magistrate first class third court Siliguri is directed to dispose of the application filed by the petitioner under section 12 of the Domestic Violence Protection of Women from Domestic Violence Act 2005, being miss case number 89 of 2020 within a period of 6 months, with a period of 4 months from the date of receipt of this order. It is further made clear without 4 months from the date of receipt of order without giving any unnecessary adjournment to any of the parties. These are numbers and disclosure.
Yeah, I'm paying for the petition number.
Yes.
In this matter, what is the allegation was that the petitioner, some unknown person had dropped some pornographic pictures of the victim girl in front of the house of the de facto complainant. And for that reason, FIR was lodged under section 14 and 15 of the POCSO Act. Thereafter, the medical was done of the victim. There was no injury on a private part and a hymen was intact. Thereafter, after 40 days of that medical report, another medical of the victim was done, where it was found that there was old injury in her private part. And on the basis of that injury report, section 6 of the POCSO was added. The petitioner was arrested and the victim gave a fresh 164 statement, where she said that at the time of giving her first 164 statement, she was afraid and that the petitioner used to had a physical relationship with her. With all these things are suppressed.
So what do you want now?
I want the section 6 to be omitted.
6 to be omitted. You file before the application before the landed judge. At the time of framing of charge, you are
already been framed. I was in custody. I could not file this discharge application. Subsequently, the petitioner granted bail. And now,
so okay, 6 is added. I mean, during the trial, if it is found that the charge 6 is not, then automatically you will not be convicted. What is necessary to delete the charge in the revisional jurisdiction? You had an option, but you have not taken the option, arguing the case at the time of framing of charges, 3.6 is not applicable. Now charge has been framed. This is not your case for quashing of the proceeding. You are telling that the 6 will not be applicable. 6 not be applicable during the evidence you, if you,
See the case diary and thereafter.
what? For what? Can the court, High Court can alter the charge in the revisional jurisdiction? Huh? High Court can hear in jurisdiction, but court can alter the charge. You have right to challenge the trial. You cross-examine if you are telling that there is no ingredients. So prosecution cannot brought more than the document which they have seized, more than the evidence. What is the 161? If they have stated more than the 161, you have a chance to cross-examine. Then
Let me solve it after.
I find so many cases are pending here.
Let me solve it.
I am giving liberty. You take the all records during the cross-examination. Whether
Then
the
you should let there be liberty to file discharge application.
what already charge is framed. The discharge is different thing. You have not filed this case for quashing. You have filed this case for alteration of the charge. Charge is already framed. After the alteration charge, it.
Discharge can be filed.
I am telling, after the alteration of the, after the charge is framed, the evidence will be started. Merely filing of charge is framed, you cannot say that you have been convicted. Conviction is after the trial. So during the trial, the evidence has to be brought on record, whether it is a 6, it is a 14, it is a 12, whatever it may. Argument, at the time of argument, you can argue the matter, there is no ingredients. On the basis of the record, this court cannot, and the trial court has framed the charge, how the revisional court can modify that? Sense suffering for
Let there
the
be liberty to file discharge.
charge framed. Sense suffering for the petitioner. Sense suffering for the state. The petitioner has filed the present application. Present application, praying for. Praying for quashing of the entire proceeding of special within proceeding of the Pendong Police Station case number 10 of 2024, dated 3rd August 2024, under section 14/15 of the Protection of Children from Sexual Offences Act 2012. Read with section 354, 354A, 354D/509 of the IPC. Read with section 6 of the Prevention of Children from why again read with section? ऊपर ही करो 14/15/6 करो ऊपर जो है ना
Earlier it was 14 and 15, thereafter. Section
pending
6, 10.
pending before the learned special judge POCSO court, special judge within bracket POCSO, Kalimpong, being special case number 19 of 2024. Police staff. Counsel for the petition submit that. Counsel for the petition submit that. There is no ingredients or materials on record against the petitioner for the alleged offence under section 6 of the POCSO Act, that in spite of the same, the learned judge has framed the charge under section 6 of the POCSO Act. Police staff. Learned counsel for the petition submit that. The petitioner could not get an opportunity to argue the matter before the framing of charge as the petitioner was in custody. He still in custody.
So how will
Was in correctional home. Police staff. Counsel for the petition submit that has no ingredients full stop. Per contra, learned counsel appearing for the state submit that after going through the materials on record, the learned special judge POCSO court has framed the charges and the petitioner being the accused in the said case will get an opportunity to cross-examining the witness, and at the time of final hearing of the final argument of the case, the petitioner can argue the matter whether the case under section 6 of the POCSO case has been made out or not. Considering the full stop. Considering the submission made by the counsel for the respective parties, this court find that after the investigation, police has submitted charge sheet, and on the basis of the materials available on record, the learned special judge POCSO court has framed the charges. And what is the stage of now? The case as the stage of evidence. And started witness examination is going on, and the case is at the stage of evidence, and the evidence of the victim girl is going on. Considering the above, this court did not find any merit in the matter. Accordingly, CRR 214 of 25 is dismissed. Police term. The petition is liberty to take all the ground during the cross-examination of the witness.
Okay, number 81. Staying for note to the.
Why?
Court number 1.
What is the matter?
I know.
You don't know. Pass over. Next.
Lord, 82, my lord, I am for the petitions. Lord, this is an application for washing of a charge sheet, and my lord, the cognizance taken. Now, my lord, the background of this case.
What is the case? What is the case? 447?
447, 188, and 34.
188.
Yes, 188 hit by 195 of the CRPC.
Who has made the complaint?
The complaint has been made by a private body, the society of that particular.
So how the 188 applicable?
Yes, ma'am.
You've taken the ground?
Yes. My lord, this is the 5th FIR that has been lodged. Prior to this, 4 other FIRs have also been.
What is the allegation?
My lord, violation of a particular order, of a particular court's order.
Particular court's order?
Yes.
What order of the court?
My lord, takes up the certified copy once. Internal page 6 is the complaint.
Yes. Who has made the complaint?
Complaint has been made by at page 8, my lord, Gopal Majumdar, Secretary, Chandmani Uttarayan Welfare Society. So, my lord, the crux of the dispute is essentially civil in nature. What has happened, my lord, is that after buying a property within Uttarayan Township in Siliguri, the petitioners used and occupied that same land and has constructed their residential house in and over that particular plot of land. Now, my lord, the society is after them. The society says that there are a few orders passed by the Consumer Forum, the district judge in an arbitration case, and my lord, a contempt rule issued by this honorable court, which was subsequently, my lord, dispensed with. Violation of those 3 orders and construction in violation of those 3 orders was, my lord, alleged. Now, my lord, within a period of 4 months, 5 FIRs on the same allegation came to be lodged. 4 FIRs, my lord, previously were challenged before this honorable court, along with the charge sheet filed therein, and my lord, they have been quashed. I'm placing the quashing order, my lord, at page 119 onwards. This is the, my lord, 5th FIR and the charge sheet. Page 119, my lord.
Yes.
Page 119, my lord, will see 4 CRR applications, CRR 183, 194, 246, and 280.
Correct.
Page 120, my lord, thereafter are the page 120 are the specifications of the FIRs lodged. My lord will find these sections completely common sections. Now, my lord, 4 of these charge sheets were, my lord, challenged before this honorable court. My lord, the finding is at page 127. Page 127, Justice Mukherjee, through a detailed judgment, has paused those charge sheets. At page 127, the 2nd paragraph. Coming to the present context.
Yes. What is going on?
They have made a complaint and that regarding that there is.
So how 188 of the cognizance charge sheet can be filed, cognizance can be taken, but under 195. And already there is an order of the court on the same cause of action. Then
Lord, I'm just placing just one judgment, the recent Supreme Court judgment on the principle of res judicata in criminal proceedings, my lord. And the frivolousness of these proceedings. Para 14, my lord, para 13 firstly. Para 13 at page 5. It says that the question as to applicability of the principle of res judicata in criminal matters have been considered by this court in several decisions. In the matters of Pritam Singh and another versus State of Punjab, Bhagat Ram versus State of Rajasthan, and the State of Rajasthan versus Tarachand Jain, this court has consistently laid down that the principle of res judicata is equally applicable in criminal matters. However, in two later decisions, namely Devendra and others versus State of Uttar Pradesh and Muskan Enterprises and others versus State of Punjab, in which one of us was a member justice, Justice Prashant Kumar Mishra, this court observed in the context of the maintainability of the second petition under section 482 CRPC that principle of res judicata has no application in a criminal matter. Considering divergence of the opinion, it would be appropriate for us to have deeper examination and reading of the law laid down by this court in the earlier decisions. Now, my lord, thereafter, there is a detailed discussion. Ultimately, the finding is that, my lord, para 19 at page 7. Para 19, page 7. Para 19 says, reading three earlier decisions vis-a-vis the two later decisions parallelly, we do not think that considering the context and the stage of the proceedings in which the matters stood and agitated before this court, there is any diversion in the applicability of the principle of res judicata. While three earlier decisions in Pritam Singh Supra, Bhagat Ram Supra, and Tarachand Jain Supra were decided basis acquittal in a previous trial, similar to my case. The subsequent decision in Devendra Supra and Muskan Enterprises Supra have been decided at the stage of quashing petition under section 482 CRPC. Thus, in both the matters, there was no final adjudication of merits. While in Devendra Supra, the first petition was for quashing of the FIR, and the second petition was preferred after the magistrate took cognizance of the matter. In Muskan Supra, the first petition was dismissed as withdrawn, whereas the second petition it was held not maintainable due to earlier withdrawal without any liberty. Thus, these two cases are totally distinguishable. In addition, it is important to bear that Sambasivam Supra was decided by 5 judges of the Judicial Committee and Pritam Singh Supra was decided by a 3-judge bench, whereas all subsequent decisions have been rendered by 2 judges bench. Therefore, Pritam Singh Supra is binding in so far as the issue concerning the applicability of the principle of res judicata in a criminal proceeding is concerned. This is, my lord, the finding. Thereafter, at para 20, it basically reserves a finding on the context of that case. Now, my lord, in this judgment, para 24 and 25 are also important, which is para 24 and 25 at page 9.
Yes.
I'm sorry, my lord. Para 24 at page 13, my lord. I'm sorry.
Page 13.
Page 13.
Para 24. Of which? This judgment?
My lord, that para 24 is from another judgment.
Correct.
Para 24 of this judgment, at page 30.
Yes.
It discusses a Supreme Court judgment, Iqbal Wala versus State of Uttar Pradesh. It says this court in Iqbal Wala and the State of Uttar Pradesh has underlined the court's duty to look into the FIR closely and with care when the challenge is thrown on the ground that the prosecution is manifestly frivolous or vexatious. The following is held in paras 9, 10, and 11. At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either the inherent powers under section 482 of the CRPC or extraordinary jurisdiction under article 226 of the Constitution to get the FIR or the criminal proceedings quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with the ulterior motive for wreaking vengeance, then in such circumstances, the court owes a duty to look into the FIR with care and little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, etc., then he would ensure that the FIR/complaint is very well drafted with all necessary pleadings. The complainant would ensure that the averments made in the FIR complaint are such that they disclose the necessary ingredients to constitute the alleged offense. Therefore, it will not be just enough for the court to look into the averments made in the FIR/complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offense are disclosed or not. In frivolous or vexatious, very important, my lord, in frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments, and if need be, with due care and circumspection, try to read in between the lines. The court, while exercising its jurisdiction under section 482 of the CRPC or Article 226 of the Constitution, need not restrict itself only to the stage of the case, but is empowered to take into account the overall circumstances leading to the initiation and registration of the case, as well as the materials collected in the course of investigation. Take, for instance, the case on hand. Similar to my case, multiple FIRs have been registered over a period of time. It is in this background of such circumstances, the registration of multiple FIRs assumes importance, thereby attracting the issue of wreaking vengeance of private or personal grudge as alleged. In this case, my lord, this is the 5th FIR and the criminal proceedings that are under challenge.
Earlier also the same person?
Yes, ma'am.
Same person?
Same person.
Society, at that time he was created for this complaint, because they have filed lots of civil cases.
So now this complaint requires the good compensation. He has to, I am passing an order to pay the compensation. Very keen to make a complaint, false complaint to everyone. Once he knows that this has been caused, again he has made a complaint and your
No,
police.
that was not after the question. The complaints were during that period.
And your police have filed the charge sheet also. When the order was passed, quashing order?
My lord, the order was passed on page 119, my lord.
What is the date of the order?
My lord, 10th of May
10th May
2023.
2023. When the charge sheet is filed in this matter?
In this matter, my lord, the charge sheet has been filed. For the charge sheet. Not page 102.
Page 9.
22, my lord.
2022, prior to that.
Yes.
So why you are not challenging this order, this also, along with this?
Lord, I've challenged the charge sheet.
No, why you have not challenged this charge sheet along with other? It was not there.
Oh, at that point, my lord, we did not receive the charge sheet.
Okay.
It was just received.
Yes. What is your defense? Nothing. Already Justice Mukherjee has given us so many gems, then again the same is to be.
Yes.
Yes, record an order. So and so offering for the petitioner, so and so offering for the estate. Petitioner has filed the present application praying for quashing of the criminal proceeding, being criminal proceeding of Matigara Police Station case number 1246 of 2021, dated 29th October 2021, under section 447/188/34 of the Indian Penal Code. And the charge sheet number 285 of 2022, corresponding to GR case number 5068 of 2021, pending before the London Judicial Magistrate First Class at Siliguri. Why you not file an application before the magistrate?
Lord,
Discharge.
since it was quashed by this honorable court, so we found it.
On the basis of the judgment in magistrate court. Kar diya. Police counsel for the petition submit that. This is the 6th FIR.
No, 5th.
5th FIR against the petitioner. Sole petitioner?
No, my lord, 4 petitioners.
Against the petitioners. In other cases also, they are the 4.
Yes.
Against the 4 petitioners. Full stop. On earlier occasion also, the the complainant of the instant case had made 4 complaints and the police has submitted a 4 complaint. On the basis of the said complaint, FIR has been chalked out. And the police has invoked the similar sections against the petitioners. The petitioners have filed, the petitioners have challenged the said the FIR and the charge sheet filed by the police before this court in 5 revisional applications, being CRR 183 of 2022, CRR 194 of 2022, and CRR 246 of 2022. All the said applications, all the 3 revision application was taken up for hearing together by the coordinated bench of this court. And on 10th of May 2023, this court has set aside, and quashed all the proceeding initiated against the petition. Now, now this is the 4th proceeding initiated by the complainant against the petition on the same, under the same provisions of law, that is section 447/188/34 of the IPC. Police. Learned counsel for the petitioner submits that. Learned counsel, the petitioner submits that. This is also the Lakshmi Township.
Yes, Lord.
Same.
Yes.
Submit that the petitioners are in association with the agents and representative of Lakshmi LUXMI, Lakshmi Township and Holdings Limited are actively engaged in construction and in over the adjacent and illegally and wrongfully, and also in violation of willful disobedience of the order passed in the proceedings in the different times by the Honorable, by the learned State Consumers Dispute Redressal Forum and Redressal Commission. क्या लिखा? By the learned State Consumers Dispute Redressal Commission, West Bengal at Siliguri, and the order passed by this court. Police. Learned counsel for the petitioner submits that subsequent to the transfer deed, the names of the petitioners and also the family members have been mutated in the record of rights, and the construction in and over the said land and been initiated in view of the sanction plan obtained from the competent authority. The counsel for the petition further submits that numerous civil litigations and writ petitions are pending. It is still pending or disposal? Still are pending with regard to their acquired land, and the petitioners are enjoying the order of the injunction against Chandamoni, CHANDMON, Chandamoni Uttarayan Welfare Society from the Court of the Learned Civil Judge Junior Division at Siliguri by an order dated 17 November 2021, passed in title suit number 2241 of 2021. And at counsel for the petition submitted pursuant to the first information report, the authorities have caused investigation and submitted charge sheet under section 188/1447/34 of the IPC and submitted charge sheet before the learned trial court. Full stop. Counsel for the petitioner submits that the learned court ought not to have full stop. Learned counsel for the petitioner submitted on in this case also cognizance was taken.
Yes.
Counsel for the petitioner submitted after submitting the charge sheet, the learned magistrate has taken the cognizance though the learned ought not to have been taken cognizance of the alleged offence as is mentioned in the FIR as well as the charge sheet on the basis of the private complaint with the allegation of the section 188 of the Code of Criminal Procedure, which is not maintainable and only unwarranted in the eye of law. Number next, learned counsel for the petition submit that on bare perusal of the charge sheet, it appears that no offence under section 447/188 of the 34 of the IPC has been made out against the petitioners. Full stop. At the learned full stop. At the learned counsel for what is your submission? Nothing. Stop. Learned counsel for the state submits that. Learned counsel for the state submits that the complaint has been made by the private society in connection with the offence alleged under section 188 of the Indian Penal Code, and if further submitted there is any non-compliance of the provisions of section 195 of the Code of Criminal Procedure in connection with the alleged offence punishable under section 188 of the IPC, even then the offence under section 447 of the 34 of the IPC can very well be established against the accused in respect of the proceeding, and the court below has not committed any wrong for taking cognizance of the offence under section 447 of the 34 of the IPC. Subpara. Consider the submission made by the counsel for the respective parties. It is not in dispute. In the present case, the complaint has been made by the private society, namely Chandamoni Uttarayan Welfare Society. And as such, the learned counsel for the state has not disputed that the section 195 of the Code of Criminal Procedure has not been complied in the present context in lodging complaint for the offence punishable under section 188 of the Code of Criminal Procedure. And Code of 188 of the IPC. Full stop. As regard the punishable under section 447 of the 34 of the Indian Penal Code, the learned counsel for the petitioner submits that they are the owner and are the possession of the property in question all along, and they are also enjoying the injunction order passed by the competent civil court, and the order of injunction is still continuing. Full stop. Is still continuing. Full stop. The similar matters has been dealt by the coordinate bench of this court in the above referred matters, and have considered the case of Sri Shiva Swami and others versus the state of Karnataka. Considered the case of Durga Charan Nayak and others versus state of Orissa, reported in 1966 Supreme Court 1775, wherein the Honorable Supreme Court held that page 126 held that following the said observation, following the said observation, it is learned counsel for the petitioner has relied upon the judgment in the case of S.C. Garg versus State of Uttar Pradesh and another, reported in 2025 INSC 493, wherein the Honorable Supreme Court held that, relying upon the judgment in the case of Iqbal alias Bala and others versus State of Uttar Pradesh and others, reported in 2023 volume 8 SCC 734, held that court considering Considering the above, this court find that the present petitioner this could find that in the present case also, the police has initiated the case under section 188 of the IPC, which is barred under section 198, 195 of the Code of Criminal Procedure. Since it has been lodged by the private society, and the allegation of the criminal trespass with the motive to commit offense, as well as the allegation of the criminal intimation, though the label separately, but are essentially an offense covered by the provisions of section 195 of the Code of Criminal Procedure, and section 195 cannot be evaded, and cognizance cannot be taken upon the offense of the misdescribing the offense or putting a wrong label on the offense by adding two more sections. In the present case, the police, after the police has initiated the section 447 along with section 188, which is not permissible under law, and thus this court is of the view the proceeding initiated by the police under section 188 read with 447 and 34 is totally bad in law and illegal. Accordingly, FIR number so-and-so, charge sheet number so-and-so, and the proceeding pending before the London magistrate is set aside and passed. The they are on bail.
Yes.
The petitioners have been discharged from their respective bail bonds.
The CD.
Yes.
Let me bring the CD, my lord.
Why?
So,
Who is the petitioner? Yes, what is the case?
see, Atrocities Act. Atrocities Act, CD will be required.
Atrocities Act.
My lord, I just want to take your lordship with a few documents, my lord. May I be given only 1 minute to do so? My lord, first, the allegations are made against the residents of Vastu Bihar and the management of Vastu Bihar by another resident of Vastu Bihar, my lord. My lord, on 16th of January 2021, my lord, at around 11 p.m., my lord, two sons of the de facto complainant in extremely drunken condition, they approached there for an alleged water logging problem. Then what they did, my lord, they outed there, they started kicking the doors of the staffs of the Vastu Bihar management, my lord. And after that, they caught hold of one of the plumbing staff, my lord, they started dragging them. The management was informed, the people came there, including a few residents of the nearby place. Two of them are petitioners herein also, petition number 1 and petition number 3. Now, my lord, the petitioner number 1, my lord, he is a retired Air Force officer who is now working with the State Bank of India. And the petitioner number 3 is a SSB officer who is posted in Bhopal. Now, my lord, when on 16 this happened, they tried to stop these two drunken men, my lord. What they did, they beat, they slapped and punched the petition number 3, and he, he was an elderly person, he fell unconscious. Man.
Who?
The petitioner number 3 hearing. Then, my lord, what happened? The management, they informed the police came there, and the police went to that place and they took control of the situation. And the police asked the Vastu Bihar management to file a formal complaint on the next day, next morning, my lord. On the next day, my lord, page number 10 of my petition, annexure A. This son of the de facto complainant, both the sons of the de facto complainant, my lord, Ravi Harijan and Kishore Harijan, they came up with the apology letter that in the we behaved in a display. So it reads, would like to apologize for displaying bad behavior with you on 17/1/2021. There were some issues regarding the work appointed to the Vastu Bihar management, during which misunderstanding arose. I was stressed because of the delay, the mistakes caused by the Vastu Bihar management. I would like to to accept my mistake and apologize to you. Hopefully you will took over the issue and whatever they be and accept my apology. After this, my lord, the formal complaint by the Vastu Vihar management was done, my lord. And after the complaint was registered.
No, this is the apology letter.
Absolutely.
You should accept my apology. Who has given this?
This is-
Swastika Darji.
Yeah, this is by Ravi Harijan. Swastika Darji is the wife of Ravi Harijan.
Ravi Harijan.
Yes, my lord. And Kishore Harijan. They are the sons of the de facto complainant of the case for quashing of which I am before your lordship. Now, my
No,
lord,
no. Who are the petitioner?
petitioners are the residents and management staffs.
Now, who is this? Who is this? The Ravi Harijan, Swastika Harijan, Kishori Harijan.
They are,
They are the complainant in this.
They are the complainant.
They are the sons and daughter-in-laws of the de facto complainant. my
There's the
lord.
complainant.
Where is the
part.
complaint?
Complainant was not there in the scene, madam.
Where is the complaint?
Complaint. Complaint is a certified copy of the complaint is given, my lord. FIR it looks
Okay,
like this.
they have given the apology. Then what has happened?
On 17th, my lord, when the formal complaint was lodged by the company management, my lord, and the police came on the next day for investigation. This particular complaint, which is the written complaint, was lodged by the de facto complaint, my lord. It reads, please refer to your notice dated 17/1/2020 directing me to personally appear before 10 of case number such and such dated such and such under Matigara Police Thana. I would like to bring to your kind notice that on 16th one in the night at about 10 p.m. water seeped into my flat from the roof of the building in which my flat contained. I in a helpless state went door to door for help to the staff of the company. No help came from anybody. On top of that, my lord, that this is important. On top of that, I was abused for disturbing them at night, and also abusive languages were thrown at me for being a Dalit. When I protested, they asked me to leave the flat and go elsewhere. After some time, I found at least 50 people, including Vastu Vihar management, at my doorsteps, abusing and threatening. This is the complaint. So now, basically, what the complainant is stating that at night, if I happen to take the contention of the FIR also, at night for water logging, water seeping problem, they went to the office of the Vastu Vihar management, where they are allegedly abused because of their caste, my lord. So, in my office, if at all, for argument's sake, I am taking that I am abusing somebody for their caste also, my lord, that cannot be taken as 313 S and R. And my lord, this is a judgment by the Honorable Supreme Court. It is a very recent judgment, my lord, on 31st of January 2025.
Kudurappa. Which one? Kudurappa. Kudurappa.
Yeah.
It is very difficult name.
Yeah. My lord, in page number 5, my lord, it explains paragraph number 8.
Yes.
The provisions R and S of section 3 of the Atrocities Act, my lord. It reads, intentionally insults or intimidates with intent to humiliate a member of a scheduled caste and tribe in any place within public view, my lord. Then the S comes, abuses any member of a scheduled caste or a scheduled tribe by caste name in a place within public view, my lord. So this has been explained. This is a very near similar case. Only the difference is my one is a company management and he was a government servant. A similar incident took place, but here the government servant was abused by the person visiting him. And my lord, the Supreme Court has held.
Okay.
Yes, ma'am. My lord, Bhajan Lal and everything is covered in this division.
My lord, may I? 2 lines. 2 lines, may I?
Yes.
Now, the document, the apology letter he has produced, my lord, at this stage that cannot be relied upon. And secondly, my lord, there is prima facie, there is material. This is not a case of question.
Sons appearing for the petition, sons appearing for the state. The petition has filed the present application praying for quashing of the proceeding of proceeding initiated by the police of PS Matigara being FIR number 48 of 2021 dated 21st of January 2021 under section 506/509/34 IPC, read with section 3 within bracket 1, 3 within bracket 1 within bracket Z.
GRS.
But FIR is something else.
Not it is written like that only, GRS.
Come to your FIR. Charge sheet file.
Charge sheet file.
Where is the charge sheet?
So my lord, neither they are appearing before the district court, nor they are appearing before your lordships, my lord.
No, where is the FIR? Yeah.
Charge sheet number.
Charge sheet. No, because what is the section they have mentioned? In the FIR, there is a G.
G, my lord.
1
GRS.
No, can you see your FIR?
Charge sheet, my lord.
Z1 31 within bracket Z within bracket ZA and within bracket capital A.
My lord, in the charge sheet it is written, my lord.
Capital E this.
Huh?
Charge sheet, my lord.
Where is the charge sheet?
Charge sheet is a certified copy, my lord. On the last part it is there.
Page number.
क्या बोला?
Page number.
3 within bracket 1 within bracket G within bracket R within bracket S of the SC and ST Act 1989. Full stop. Heard the learned counsel for the petitioner peruse the materials on record. This court find that the petitioner has made out the arguable case and has to be heard on merit. Accordingly, the petitioner directed to serve notice upon the.
It was served, my lord.
Served.
It was served, my lord.
Police, I think.
No, there is an order of the court.
Yes, my lord.
Where?
The order court ordered them, as they were not appearing the private respondent, my lord. The court ordered for the police, ordered the police to serve them.
Yes,
And
that's
the
an
police
order.
served them, my lord. I have the
Insert
receipt
in
copy
prepared
also.
interpretation, having read the to serve the copy of the petition. No? Yes, which one? No, वो तो already है, order है, get the पूरा card.
It was served.
Concession suffering for the petition, concession suffering for the state. Consider petition have argued the matter length, but the land counsel for the respondent. Now counsel for the state press for time for production of the CD. Let the matter appear on.
Please do, my lord.
On. Appear on 20th May. The state is directed to produce the CD on the date fixed. 20 May.
Much.
Yes.
I am for the private respondent, lordship.
Yes.
Conducting advocates out of station, if his flight got late. That is the only reason he could not come to the court, my lord.
Yes.
My lord, actually, I am not advocate on report, conducting advocates.
Okay, no problem. You see it. The court will go through the record and pass out. Once the party has filed an application, the court is there. Where is your advocate?
My lord, advocate for some urgency.
Okay, the urgency let it do the urgent work. The court will do his work. No. Sorry. Yes, CD is there.
No, lordship, it is not.
Why?
Lordship, it was deposited 1 second. Written there.
I am appearing on behalf of the de facto complaint, Lordship, in this matter.
Yes.
Lordship, actually, in this matter, there was a post shared by this accused over a dispute that the Darjeeling is having a red light area, and wherein the video was not of Darjeeling. Actually, basically, it was of elsewhere, and it was posted. And after this, a complaint was filed by a practicing advocate of the Darjeeling Bar Association on this regard, Lordship, the de facto complaint out here. So Lordship, after that, two accused were arrested. I think after that they were granted bail, Lordship, in this matter. So till date charge sheet has not been filed as per my knowledge is concerned, as because it is not annexed with the petition, Lordship.
Correct.
Still under investigation, Lordship.
Charge sheet filed? No. You are not on this. So and so suffering for the petitioner, so and so suffering for the state, and so and so suffering for the opposite party number two. Police law. Counsel for the state submit that the investigating is still going on. According to case adjourned, let the matter appear before the next circuit. Next.
Your Lordship. Your Lordship, am I audible?
Yes.
Hello. Your Lordship, for item number 85, Your Lordship, I beg to inform one aspect. Although I am ready with the matter, however, the mother of the learned advocate on record has had a stroke, for which the learned advocate on record has had to go to Jalpaiguri. Now he is having those judgments on which I will be relying upon my argument. Your Lordship kindly fixes this matter on Monday. Your Lordship will be arguing this matter on merits. Otherwise, if you're...
I'm for the private respondent.
What is the section?
Section is 318 cheating, 336(2) forgery, 336(3) forgery for purpose of cheating, 338 forgery for value security,
Charge sheet
340.
submitted?
No, madam, no.
Charge sheet not yet filed?
No, madam.
Your Lordship, my primary
My lord, the thing is that they have applied
Your Lordship,
anticipatory bill, which was granted on certain condition that they should deposit the power of attorney within 10 days. Within 10 days. So that they have not done. And accordingly, there was a prayer for cancellation of the anticipatory bill, which has been cancelled. Now they have come before my lord.
Anticipated bill cancelled.
Your Lordship, I have come.
Now they got the
Yes,
bail?
Your Lordship.
No, your lordship.
They got the bail. They are on bail or they are in custody?
No, Your Lordship. I have Your Lordship. I have assailed the cancellation order on its own merits, Your Lordship, based on the legality of it. Your Lordship, the only reason why my anticipatory bail was cancelled was because of one factor alone, is that I failed to appear before the investigating officer. It is not the case of the state that I have threatened any witnesses. It is not the case of the state that I have tampered with any witness. Lordship, my only humble submission is...
If it is a conditional bail, my lord, and if it is
Your Lordship, the cancel...
automatically on that ground, it can be cancelled. It's very clear, 439(2).
Your Lordship, there are multiple judgments which states that perceived indiscipline cannot warrant a cancellation of bail. Your Lordship, cancellation of bail has to have an extraordinary grounds.
It's a conditional bail.
So
If your Lordship deems it fit
and
allows me, I can...
You are not producing the original power of attorney which is placed before this court along with the other document. So you are not playing for the...
Your Lordship kindly,
So
Your Lordship
if you are not
kindly comes to the bail order.
Correct.
Lord,
Your Lordship kindly
they have
comes to
admitted,
Annexure
they have
P2,
admitted,
page number
they have admitted
70.
learned advocate for the
My intent,
power of attorney.
sir, it's...
They have admitted
Sir,
that.
it is my application, sir. Let me, sir, allow me to submit. Your Lordship kindly comes to Annexure P2, page 17. It is the anticipatory bail order which I was granted. Kindly sees the middle para. In the, on the other hand, at the time of hearing, learned advocate for the accused petitioner submitted the original registered power of attorney along with principal attorney and identifier, etc. At that point, Your Lordship, I had no issues submitting the power of attorney. At this point also, Your Lordship, I have no issues submitting the power of attorney. The only reason why my prayer is very simple, Your Lordship. Kindly allows me some safeguarding measures so that I can go and comply. My bail has been cancelled solely because of the fact that I was unable to appear, and nothing else. And Your Lordship, in that regard, Your Lordship, I would like to place some judgments. However, today on that ground, Your Lordship, my abilities are fairly limited.
Sir, you are not
Kindly
cooperating.
allows.
You are not cooperating with
Right,
the
my lord.
investigation. Investigating is
Conduct
going
is
on.
not
How
good.
the or your how your original application will take? What
Right.
the court will find in the CD if you are not if you are not cooperating with the investigating agency.
Your lordship, I intend on cooperate. Your lordship, which is my humble prayer. I intend on cooperating with the investigating agency. I am saying this undertaking that I will hand over the power of attorney. My only issue is that my anticipatory bail was cancelled solely on the ground without affording me a secondary opportunity that I was unable to go there. In fact, your lordship would kindly see the cancellation
Sir,
order.
you have
It
accepted
it has
you have
been
accepted
submitted in the
you have accepted the anticipatory order dated 8/11/2024, which itself
yes.
stated that the order of granting anticipatory bail to the present petitioner shall be cancelled automatically. So where is the opportunity? You have, if you are not complied with, you are not appeared with the
Your
investigating
lordship,
officer, you are not
your lordship,
supplied the original copy of the power of attorney automatically. So where is the question of the opportunity, sir? I am
your
fixing.
lordship, in that regard,
I am fixing on Tuesday.
your
If you will
your
not,
lordship,
if you will not surrender before the court, then I will dismiss this matter.
Grateful, my lord.
your lordship, if
Suffering for the petitioner,
your lordship,
suffering for the
one
state,
indulgence.
counsel
Will
for
this
the.
matter be pending on?
Yes. The petitioner has filed the present application challenging the
The 20 days after the bill was granted, he has not complied with the order.
Your lordship, will this matter appear on
praying
Tuesday?
for quashing of the criminal quashing of the criminal miscase. What is the criminal? What you prayed for here?
Your lordship, I have prayed for setting aside of the order cancelling my anticipatory bail.
That order is
That is
challenged.
on. Your lordship sees the prayer.
Where is the 21st? Where is the order dated 21st, 22nd?
Your lordship, it will be in the supplementary affidavit, your lordship. Lordship, one indulgence. When I will surrender, your lordship, will I be protected in any manner?
क्या बोला? No. Praying for challenging the order passed by the learned session judge Jalpaiguri dated by order number 14 dated 22nd of January 2025, wherein the learned session judge has cancelled the anticipatory bail granted by the learned session judge by order dated 18/11/2024 in CMC number 1938 of 2024. Today, when the matter is taken up for hearing, counsel for the petitioner prays for time. Learned counsel for the state submit that in spite of the order of the cancellation of the anticipatory bail, neither the petitioner have surrendered before the learned trial court, before the competent court, nor has not surrendered before nor appearing before the investigating officer for cooperating with the investigation. In view of the above, the case is adjourned. Let the matter appear on 20 May 2025. It is made clear that by that time, if the petitioner failed to cooperate with the investigating officer, appropriate order will be passed.
Obvious.
Your lordship, one indulgence, since warrants have been issued, the moment I go and cooperate, I'll be arrested.
Maybe.
Your lordship, then the petition will get infructuous, your lordship.
Maybe. You cannot take all the things in both hands, sir.
Your lordship, I'm at mercy, your lordship. Kindly.
All the other matters.
Lord, I'm for the petitioner. Lord has heard this matter extensively yesterday, my lord. 125 proceedings, 6,000. And there are DV Act 3,500. My lord, that was challenged before the district judge. District judge made it 20,000, in total 26,000. And my lord was inclined, my lord, to interfere with the order, subject to me paying rupees 15,000 per month as interim maintenance. My lord, I have obtained instructions, my lord. I have no difficulty in that, my lord. I'll be abiding.
What?
I'll be paying 15,000 interim.
What your daughter is doing?
She passed class 12,
Ah.
81%.
Ah.
She is preparing for CLAT, my lord. She have taken admission. This is the amount, 65,000 rupees. She's supposed to pay for that. 35,000 the mother has already paid, my lord, and she'll be entering into law, my lord. The
CLAT?
law course.
Flat hua? Flat over?
She's doing the course now.
Ah.
And thereafter she'll
Total
be
fee
exam.
65,000. So installment 32.
She'll be entering into the law college, my lord.
Hmm.
Law college. After the CLAT exam, my lord, it will depend upon the ranking, my lord.
Not yet appeared.
So for that also the
Whether she had appeared in the CLAT? No. She will appear in the CLAT exam, not yet appeared.
with the course of CLAT, my lord. CLAT course is what?
Crash course. Some training courses, my lord, Shira.
Yes, my lord. And after giving this exam, my lord, she'll be entering into law college. And for that also the expenses are very high, my lord. And your lordship already knows, my lord.
So after that, your expenses will be down because he will be advocate. So you can really.
Till that time, my lord, the father has to bear the expenses.
Now, my lord,
my lord.
one thing.
Now, my lord.
One thing, my lord, very clearly I am submitting. I have taken instruction. My lord, if it is about the education of my daughter, my lord, I am ready to bear the cost of her education. But in that event, my lord, the maintenance amount, my lord, has to be reduced. I will bear the cost of education separately. And my lord, I undertake that before your
What you are doing?
As per instruction.
What you are doing?
My lord, I am a junior engineer in the field.
Junior engineer.
Yes.
You are getting the what education allowances? All the certificate, all the bills is to be submitted, and you will get the education allowances from your department.
My lord, I have a son as well. My lord.
Maybe either 2 sons, 3 sons. If you are a government servant, all the education expenses, if you submit the bill, you will get the reimbursement from.
But I am unaware of this provision, whether this is.
I don't know whether it is.
No, it is not. So far, my knowledge is not there.
It is not there.
No. This is for the central government employee.
So okay, now she is pursuing the CLAT, and she will get the admission. If so, not the CLAT, if she will get the admission in the college. So
I'll bear her educational cost. But in that event, my lord, then the maintenance has to be reduced because, my lord, I am challenging the proceedings that my wife is having an extramarital affair. She is staying with a different person. So if, my lord, in the maintenance proceedings, my lord, if I win, then she will not be entitled to any maintenance. So in that event,
Word itself is a domestic violence.
So, my lord, there can be two workable solutions. First, my lord, as your lordship has, it has fallen from your lordship 15,000 rupees interim maintenance. My lord, that is also fine. If, my lord, separately the educational cost has to be borne by me, that is also good, my lord, but then the maintenance amount has to be reduced.
So the 125 total 6,000.
6,000.
Correct.
Fine.
125 is total 6,000.
Yes.
And this domestic violence act, initially it was the
3,500.
3,500. Now court has enhanced.
Yes.
Court has enhanced.
Enhanced to 20,000. Total 26.
20,000. Total 26,000.
Yes.
Correct.
Yes.
So what I subject to correction, what I propose to do.
My lord.
If both the party agree. So with regard to the 6,000, you are not challenged, 6,000 you have to pay.
Yes.
And plus this, the Leonard Session judge passed an order of 20,000. Instead of 20,000, I am getting of 10,000, 16,000 rupees. 10,000. Correct. And with regard to the admission and all these things, what your daughter will give them, all the fees is to be deposited by you.
Lord, that will be too much for me. Lord, kindly understand, I am ready to bear the educational expense.
Correct, that's
But,
why.
but monthly maintenance of 60,000 will be 16,000 will be too much for me. Lord, kindly understand.
Your wife is not working.
She claims not to be working, Lord, but
Correct.
she is a private tutor, Lord. She has, Lord, ample income, huge income, even more than me. But that is not documented, Lord. So
But the daughter's expenditure has.
I will bear the expenditure,
Yeah.
but then kindly reduce the maintenance amount.
15,000.
Lord,
Okay, I am reducing 15,000, nothing else.
Lord, let it.
15,000 nowadays.
Lord,
And the all the school expenditure, the college expenditure has to borne by you from time to time.
Matlab, the residential rights are with my wife. She has residential rights. What? No. There is
There's a direction.
That is, she is now staying. in
You are staying, you will go to the America in spite of the order. What the court?
Stay with her.
Go and stay.
In Kolkata, my lord.
Go and stay.
My lord, if
There is a judicial order. There is a judicial order.
the petitioner is present over here, she's willing to stay in Kolkata, my lord.
Where this residence is situated?
You are going to see page 134. The Calcutta flat residential rights is already given by the district.
That's where this residential.
Calcutta.
She's willing to stay in Kolkata.
Sonarpur, South Chowbish Pargana, West Bengal.
We are page number 134.
134. Madam.
Yes.
Second paragraph. After the material part. Fourth paragraph.
Flat 62A Baliganj Court.
Respondent also restrained from dispossessing or any other manner disturbing possession of the agreed wife from the shared also RNC Road, Rajpur, Nivedita Bhavan, Sonapur, 24 Parganas. This one.
Yes.
This is lying vacant.
Yes, the possession.
You are not even having the possession over this
No,
building.
my lord. She's not staying over there.
So why you are not staying?
Because she's staying in Alipurduar with her.
Why you are
My
not
lord,
staying?
First, it was her first matrimonial house. Thereafter, the husband bought a flat in Kolkata.
Madam, that leave aside. Now the district.
That flat is also in her name, my lord.
Which flat?
The flat in Kochba, my lord. But she is not allowed to be enter into that Kochba house, my lord. By the husband, my lord. That's why she lost the 498 case, my lord.
This RNC Road, Rajpur, Nivedita Bhavan.
This is her matrimonial house where all the family members are residing.
So you are not wanted to reside here.
After this place, she was residing in Kochba only, man.
Correct.
And it's because the voter ID card had this address, my lord. That's why the court has given this address. Actually, she was residing in Kochba with the husband.
You are not challenging this order.
Residing in Kochba, my lord, in Kolkata.
Correct.
She also wants to stay over there only with her daughter and son, my lord.
So now where you residing? Are Kolkata? Alipurduar, whose house?
Rental house.
Rented house, you went to the rented house, leaving aside how the court can.
She wants to stay in
Go.
Kochba in Kolkata. If an order is
What Kochba? What the order is passed by the district judge, you have to decide.
South Chowbish Pargana, my lord.
Yes.
That has been wrongly passed, my lord.
No, sorry. You are not challenging this.
May I, my lord. My lord, your lordship has, my lord, with regard to the query of interim maintenance, how it is required to be passed, that has been elaborately discussed in Rajneesh versus Neha, my lord. I would like to show this judgment to your lordship, my lord.
Yes.
Paragraph number 62.
Yes.
At present, the issue of interim maintenance is decided on the basis of pleadings, where some amount of guesswork or rough estimate takes place, so as to make a prima facie, please don't talk now, so as to make a prima facie assessment of the amount to be awarded. It is often seen that both parties submit scanty materials, do not disclose the correct details and suppress vital information, which makes it difficult for the family court to make an objective assessment for the grant of interim maintenance. While there is a tendency on the part of the wife to exaggerate her needs, there is corresponding tendency of the husband to conceal his actual income. It has therefore become necessary to lay down a procedure to streamline the proceedings, since a dependent wife who has no other source of income has to take recourse to borrowing from her parents' relative during the interim to sustain herself and the minor children till she begins receiving interim maintenance. After having section 63, para, my lord, if your lordship comes to paragraph number 72.3, which is in page number 369. Page 369.
Yes, continue.
The respondent must submit the reply.
That is the affidavit of asset. Correct. Then.
When the magistrate court considered the maintenance, my lord, the affidavit of asset declaration was not given. So it was only when it was given before the
So that's why, madam, see.
when the district judge has very correctly passed the order.
Okay, I am passing the merit. Hearing concludes hearing. If you are not coming on to the conclusion, I will pass up.
It's betterment.
So why you want to go there? Time is to be wasted.
The lordship is better, my lord. Kindly pass, my lord. But my lord, I just wanted to say that 26,000 rupees is a very small amount which is being paid to her, my lord. She has,
What about the son?
the son already he's spending.
That's why. What about the son? If 26,000 rupees will be given to you.
14,000, my lord. 14,000 he's spending for the son, my lord. What about the
Okay. Now,
my lord,
the matter is heard in merit, but it is found that the counsel for the respondent is very adamant. Let the matter go out of the list. And you are bringing the daughter on the court.
No, that's not daughter, that's a wife. That's the wife, my lord.
Yes, call the matter.
I'm grateful.
Now, this is an application of contempt.
Rejects, my lord. If the lordship kindly takes up the matter, my lord.
Item number?
85.
Yes.
This is a contempt. Lordship order.
Where is the order?
24/5/2020.
Where is the order?
A1, man. My lord, it is at.
Where is the order? Page number?
It is after the first order after the 14.
The Commissioner Siliguri Municipal Council directed to dispose of the representation by passing a reason in speaking order within a period of 8 weeks from the date of receipt of the order. What is the date of the order?
My lord,
14th May.
2025, my lord. It was subsequently communicated, my lord. The notices were issued. Inspection was conducted, but my lord, till date, no order has been passed. My lord, and medical nursing home is being run illegally in that building, my lord.
When you communicated this order?
My lord, after my communication, my lord, they have included notice for inspection, my lord. On 18/6/2024, the inspection took place. Thereafter, my lord, a notice for hearing was there, my lord. The inspection report says there are severe violations. Now, my lord, what they have done, they have only measured half portion of the building and they have ignored the other half, constraining the petitioner to again make an application pointing their discrepancies, but no action has been taken, my lord. Till date, my lord, the building is in the same position and a nursing home is being operated in from there, my lord, risking the lives of several patients.
Yes, when you communicated this order?
My lord, it was communicated on the very next day, my lord.
Where is the order? Where is the communication? Forwarding letter?
My lord, that, my lord, is not the next, my lord, but.
So that is the main crux of the content matter, sir.
It was subsequently they have issued notice, my lord, based on the.
I don't. Court is asking when you have communicated this order.
My lord, it was communicated. My lord. It was communicated on 14/5 only, my lord. I am not holding the. Service, my lord.
Yes, well, then after the inspection, what has happened?
My lord, they have found a report. My lord, kindly takes that 11/7/2024, my lord.
Correct.
My lord, in that they have said that 1, 2, 3, 4, 5 violations are there.
Correct.
But my lord, they have only inspected half the property. Not the entire complaint was not.
Okay,
considered.
this is the inspection. Then there are also what is happening.
Representation that you have only done the half inspection, my lord, and then nothing was done, my lord. They sat idly, that constrained me to issue a notice for contempt, my lord. And that was subsequently issued, my lord, and it was also received. My lord, it is received on 14 November 2027. But till that
Census and
was-
suffering of the petitioner. The petitioner has filed the present application on the allegation that the alleged contemner has not complied with the order passed by this court dated 14th May 2024. Full. 2024. The petition is directed to issue notice upon the who is the contemner?
My lord, the contemner is the Commissioner Shilpa Municipal Corporation, my lord. Her name is
Jalpaiguri.
Madam Shirin Y.
Notice
Bhutia.
upon the alleged contemner. And to file the affidavit of service on the next date fixed. Please the matter on 20th May 2025. Issue notice, come on 20. Item number?
Petitioner is challenging the order dated 9th of April 2022, which is page 26, my lord.
Page
26.
26.
Our petitioner granted statutory bail. And because my lord charge sheet has not submitted, and my lord, in the statutory bail, there is an order that 10,000 and 10,000, 10,000 is registered and 10,000 is local. In my lord, which is my lord, 50 lakh of the landed property must be given to the.
The accused Abhinav Kumar may find 20,000 with two sureties, of which one amount having landed property.
Thereafter, my lord, it has been modified before the landed code and it is modified to my lord 35 lakh. But my lord, the petitioner did not have any money to do that, my lord, let it be reduced to 10,000 and 10,000 and 10,000 my lord cash sharing.
Property worth of rupees 35 lakhs.
My lord, previously it was 50 lakh under the Jalpaiguri Tower.
Where is the order?
My lord,
Previous order? Previous order?
Page 23.
Page
23.
23.
Yes, ma'am. My lord, therefore, in the view of the above premises, 20,000 with two sureties, 10,000 each, one of whom must be local, having landed property worth 50 lakhs within the local limits of Jalpaiguri Tower.
Therefore, in view of the premises present, Abhinav may find interim bail with two sureties of 10,000 each. One of them must be local, having landed property 50 lakhs with the Jalpaiguri township. What is the case against you?
My lord, under indication.
What?
My lord, 35 kg of ganja has been recovered.
35 kg of ganja.
Allegedly, my lord.
And
No, it is a trial law from the Supreme Court that my lord, the bail amount should.
you are not served the prosecution.
No, my lord, this is the admission stage.
But this is not to admission stage. Census and suffering for the petitioner. The petitioner has filed the present application. Where is the order? 27.
26, my lord.
Census and suffering of the petitioner has filed an application challenging the order number 20 dated 9th April 2025. 2025 passed by the special judge under NDPS Act, First Court Jalpaiguri. Petition directed to issue notice upon the state and file affidavit of service next date fixed. Leave the matter on 20th May. No, Tuesday. Tuesday. ठीक है